Act, the Trade Dispute Act, the National Industrial Act, those ones that are written down, right? So because what happens is that the State House of Assembly, National Assembly, they make these laws, and you hear something like it has passed the first reading, second reading, and then it has gotten an approval. The president has given an assent, he has signed up on it and said this, I've signed this into law, and then it becomes law. That's also another source of law, labor law, right? Where we get our laws from. And then the third one, which is the judicial precedent, right, that I mentioned earlier, which is the case laws. So what happens is that we've had all this, foundation, all these laws that have come into place, but as we go along, you might be seeing things that's the first time we are seeing this. When these laws were written, because man will never know everything. No single person is perfect. You don't know it all. So as it's coming, as those things are coming, you discover, oh, so somebody can actually do this. Okay, so we now take this decision, and then it becomes the guiding decision onwards, right? And are related to those decisions that can be given by the Supreme Court and the rest. And then we call that, when that happens, it becomes the locus classicus. It becomes the law that will have to hold on to at that point for that principle of law. Whenever you mention that principle of law, and we'll see some of them in our conversations, we hold on to that case. This is the case I'm relying on right now because it's a guiding principle. So those are the cases, the decisions given by the courts. And then we have the collective agreement, right? Collective agreements, you see it's where we have the industrial practice or industrial labor practice. If you have unions in your organization, I haven't worked in an organization that has a union, but I know Dr. Liemi has worked in one of them because I've been in his class when he gave us some instances of how disciplinary committees set up in this kind of organizations, how their policies are created, and I understand. And also, there's also another guide, Mrs. Linda, Jokonla, right? She has also, helped us to understand how this happens. And I understand that for the collective bargaining, agreements, or what they call the collective bargaining agreement, CBA, in those organizations, what happens is that the unions, they've already written out what they want to kind of guide them, right? And then they go to discuss with the management, like they're on the table to discuss, and they agree with the management that this is what you want to guide anybody that is a union member. But what now makes it binding on them is that they will have to adopt it into their policy, right? So they now adopt those kind of conversations into their policies, right? And then now that's now becomes what is it called? Part of the policies that guide that organization. So it's a source of law. It's a source of employment law for that organization, right? To the extent that it is, because it is unique to that organization. It is peculiar to that organization. But if you now want to talk about, so I'm in this organization, what am I going to look out for? What guides me? Collective bargaining agreements or collective agreements is one of them. It's called a gentleman's agreement, right? And then there is the rule of work or the service rules. What do we mean by the rule of work or the service rules? These are the contracts of agreement that you've given to your employees. So when you give a letter of employment, that's a contract. That's what you've stated there. When the person reads it, signs it, it binds both of you, right? It is a contract of agreement, right? So it's a rule of work. It binds you and that employee. Also, when you put up handbooks, when you put up policies in your organization, right? And then for the employees, it's also very good that when they read the handbook, that's also very good that they attest, that attestation part where you have to sign that you've read, you've understood that policy, and then you're guided by that policy. The reason is this, that when you have the disciplinary committees, DCs, right, or maybe what you call listening committee, someone is called, somebody has done something and maybe maybe misconduct, right? Let me not categorize, because sometimes when it's gross misconduct, you're being shown the door, right? But yeah, but you still have to listen to the person. The person won't say, oh, I'm not aware of this, I haven't heard about this before. So this is also a source of law. But I must put a caveat here for the rule of work or the service rules. The reason why I'm putting this caveat is this. For this, right, the fact that you, an employer, has written a contract of agreement, contract of employment, or you've put down, policies, employees handbook, and say that, you've signed it, it's going to be binding on us, right? The lawyer said once we sign an agreement, it's going to be binding on the two of us, so you must do what is written there. That is not 100% what applies here, because the law we look at, right? The law we look at when you do something, right, to that employee, and that employee is aggrieved. Maybe you've terminated the person or something, and it takes the employer to court. When it gets to court, what the court is going to ask you is, what you've put in that your contract of employment or your policy, is it reasonable for a reasonable man? Is it reasonable for a reasonable man to undergo that kind of a thing, right? So the fact that you've gone there to put things, you should not put things there just arbitrarily, just putting things to say, yes, once you're a member of this organization and you sign it, it is binding. No, it is not. When it goes against the law, right? It will not be binding. The law will, the court will frown at it. They will tell you that it's not reasonable, and they will give judgment in favor of that employee. So there is this thing that we say in law, it should not be something, even though sometimes it's related to the customary aspect, but it shouldn't be, you shouldn't actually put things in your contract that when people hear, they want to close their ears and say, is this slavery? Do you ask a normal human being to do this? Things that are repugnant to justice, equity, and good conscience. You shouldn't put things there that, when somebody hears, like, seriously, you ask somebody to do X, Y, Z. This is slavery now. Why should you put this? So it is not on its own, that it's, I've put it there, I've put it in the contract. You've read it now, you signed it, so it is binding. It is not. So this says that we should be careful, the kind of things that we should put on our policies or the contracts, that we are relying first on the, on the laws to see that those things that we are putting there, they are compliant with what the law has provided. And then there is International Labour Organizations Convention, that's the ILO, which has won its 7 member states as at February 2025. And what happens here is that those member states, they have conventions, and then when they sit in during those conventions and take decisions and make these conventions, these member states, that's the countries, that the member states, they go back to their countries and ratify this, these conventions or these laws. When they now ratify it, meaning that we've adopted it and it has now become part of our law. Not until they adopt it, it will not be law in their country, right? But when they adopt it and say, like, we're upholding it, right? We like this and we want it to be part of our country, our laws, then it becomes part of the laws. All right, those are the sources of the Nigerian labor law. Maybe there are others that, if I've missed anyone, feel free to drop it in the chat. And then we talked about the statutes, the codified laws, that's the ones that are written. And please stay with me. It's very important that we get this, this foundation, right? And it enables us to have meaningful conversations as we go along. It might be sort of, boring at this point. Maybe I'm just saying things around, just legal terms and all of that, but please stay with me. So we now have the codified laws. So the ones that are written down, that's the statutes that I mentioned, right? Those are the ones that you can see on my screen. So because they are the laws that are not written down, like the customary laws, for instance, but however, the ones that have been written, like I said, you can see them on the screen. The Nigerian Labour Act, which is, the, what we call the ground norm. When you say something is the ground norm, it's like the foundation on which other laws are built for the labor law. But for the foundational laws for all of us in Nigeria is our constitution. The 1999 constitution as amended, right? That's the foundation, like the father of all laws. If you create another law today and it is inconsistent with the constitution, that is one part of it, of that law that you've created, maybe by omission or it can happen, right? It is inconsistent with the provisions of the constitution. The constitution will be supreme, or will precede that other law to the extent that that part of the law is inconsistent with the constitution. Let me say this in a different way. If for any reason there is any law today in Nigeria that has a provision, just you read one section like that, and you find out that, hold on, this thing contravenes, one part of the constitution, one provision again. I am saying that we've stated in the constitution will supersede that in that other law, because the constitution is the ground norm. It is the foundation of all laws, where our human rights, rights, the rights that we have are established, right? So that other law will be inconsistent to the extent that is, those provisions are, scrap that. That other law will be null and void. It will no longer be valid to the extent that it is inconsistent with the provisions of the Constitution. That's what I'm saying, right? So the Constitution is the supreme, is the most is it revered now, right? If I have to use that word. And then we have other ones. There's a litany of them: the Pension Reform Act, the Factories Act, the National Social Interest Fund, Industrial Training Fund Act, National Health Insurance Scheme, National Housing Fund Act, and the rest of them. And I must mention the last one, which is the Public Service Rules. The reason I had to stop to mention this is because whilst we recognize that we have the Labor Act, which is the also the ground when we talk about the labor laws, the employment laws, right? We have the Public Service Rules, which guides the public service, the civil service, right? Because I get these questions a lot when I make posts. It's been a minute since I made this kind of post on LinkedIn. I get people asking those questions. Because of it, I'll have to always put that caveat, right? People coming from the civil service, civil service professionals, they're asking questions to say, oh no, this doesn't apply to me. This is the way that it applies. And they are correct. Because what guides them is the Public Service Rules. Because their unemployment is what we call the employment with statutory flavor. Their employment, right, you must follow the status, how it has been written in the Public Service Rules for everything, both from recruiting them to, their probation, to confirming them, to terminating them. You find out that some of the cases that we have under the termination, some of those cases, when you say that those cases are to do with, a public, but like a government institution or something like that, right? That's when you hear something like somebody was reinstated in his position. When you ask them to go, when their employments are terminated and it did not follow the procedure that is supposed to follow, what happens in this instance is that the law will ask them to reinstate that person, because it's not a private employee. That's why I remember growing up, when you ask people where do you want to work, they say, I'm looking for government job security. If you ask the reason, they'll tell you job security, because they are employed by the statute. It is not Chinua and daughters that employ them. So you can't just fire them. You can't just ask them to go. You must follow the proceedings. If you don't follow it, they can take you to court. If they win, the court will reinstate them. But if it is the other way around, where it is a private organization, you find out that, when such thing happens, let me even say that the court now, on the merits of that case, awards judgment to the employee. You know that saying, you cannot force an unwilling employee onto a willing employer, and vice versa, right? They can take the person back, but maybe in 1 month, in 2 months, they ask the person to go for some other reasons, right? So I must mention that there is the Public Service Rules that guides the civil service. And then going onwards, why do we have this? I've mentioned this as I was putting out the foundation for this class, that before now what we had was the common law. We had the master-servant relationship. You can hire and fire at will. The masters can do anyhow. That the employers, they can just move things around, and then the employee is always the one at the losing end, crying and all of that. But this came to play, and it's essential because it will protect both the employer and the employee, right? It can prevent workplace disputes and litigation. It also promotes fair treatment. That thing that we say, unfair labor practice. What actually is unfair labor practice, right? We also ensure compliance with government policies. The reason why, the employment laws have come to stay, and they guide us in what we are doing. So what does this cover? Contracts, employment contracts, working conditions, termination and discipline, compensation and safety, pensions and statutory deductions. Someone put in the chart that pension is one of the things that worries. I don't remember if it's a he or her now. Union relations and dispute resolution, right? Okay, so it is time for us to discuss. I've been the one speaking. I'd love to hear from us now. I'd love to have a volunteer, please. Help us to read the case in front of us, and then we can, dissect this case and discuss. Anyone, if you can please raise up your hand, I'll see you, recognize you, for you to help us to read this case. And we'll be having some of them as we go along. No hand yet. I'll need a volunteer, please. Ahmed, please go for it. Thank you. Please.
All right. Yes, so 1, navigating employment contracts. Chinelo works as a senior project coordinator at Nigerlogic Consulting, a reputable tech staffing firm based in Lagos. One Monday morning, she received an urgent request from one of their major clients, United Money Bank, a fast-growing commercial bank with operations across Nigeria. The bank needed 200 personnel to resume work immediately across 3 states, Rivers, Ogun, and Oyo. Fortunately, Chinelo had a pre-screened pool of candidates ready for deployment. Without issuing formal documentation, she instructed her colleague, Tunde Okunku, the operations lead, to begin notifying the selected individuals. Tunde, acting swiftly, contacted the 200 candidates and verbally informed them to resume work at the designated bank branches. He assured them that their formal offer letters and contracts will be issued within 2 weeks. Most of the candidates, particularly the drivers and support staff, were content with this arrangement. They trusted the firm's reputation and were eager to start earning. However, Emeka Adebayo, one of the IT support technicians, raised concerns. He insisted on receiving a formal contract letter before reporting to duty. Emeka felt uneasy about starting work without clear terms, especially regarding salary, duration, and responsibilities. Now, Emeka has approached you as a friend, seeking advice on what to do. 1, is an oral contract of employment valid? 2, when an employee is employed by company A and deployed to company B to work, is a contract valid?
Thank you so much, Ahmed. Thank you. Thank you. All right. Thank you, Ahmed, for reading that. Let's discuss. We've seen this case, which could have just been something that happened maybe in my own organization or your organization, but it can be an everyday issue that we will have to deal with. Every day on different HR platforms, I see HR professionals, including myself, coming in, and there's nothing wrong with that. That's how we share knowledge and learn every day. To ask questions, I'm faced with this dilemma in my organization. What do I do? So somebody has just put this in a WhatsApp chat, for instance, and asking this question. I would love to have volunteers to, respond to this, answer this question. Ahmed has helped us to read it, but let's also hear from others. Who would love to answer this question for us? Ahmed says, is an oral contract of employment valid? When an employee is employed by company A and deployed to company B to work, is this contract valid? Angela, your hand is up. Please go for it.
Good evening, everyone. Can you hear me?
Yes, please, loud and clear.
Okay. I believe that by law, the employer has 3 months to prepare a formal contract, after which the employee can raise reservations or objections if a contract is not given to him. By law, he has a window of 3 months.
Okay, who is speaking to us now? Once more. I'm sure. Okay, Angela. Yes, Angela. Thank you. Thank you so much for your response, Angela, or your submission. Ahmed, is your hand still up, or is it old hand? Angela, you can mute now because of the interference we are getting from the background. Please mute. Where is Angela? I need to meet you now. Okay, thank you. Uncle K, please go for it.
All right, thank you very much. The question is oral contract valid? Yes, very valid. If you go into contract orally with someone and the person does the job for you, it becomes an implied contract and you pay the person. That contract is very valid. Thank you.
Thank you so much, Uncle K, for that submission. Tosin Alabi, let's hear from you. Then we hear from DK Emeka, Abdul Hafiz, Peter, and then we'll see what is in the chat. If you have your response, you can also put it in the chat. Tosin, let's hear from you.
Good evening. Can you hear me?
Loud and clear.
All right. So yes, like everybody has said, an oral contract of employment is valid. However, I think there's a place of clarity and understanding of what you're going into. So I think it was the job of the consulting firm to communicate what the client company is offering them as employees coming on board, especially when they're being told to resume in different places, right? And this is one of the things that Adebayo Emeka wasn't really what didn't understand. I want to believe. So there's a place of clarity, and I think the agreement was not clear enough. It was not communicated enough from what was gotten here. And the second question says that when an employee is employed by company A and deployed to company B to work, is the contract valid? I think there's a place in law where we can contracts for our contracts, or where you can actually move people to other companies, right? It is valid. However, there's a place of clarity, and after 3 months, you've not gotten your contract of employment of your offer letter, and the things are not that you spoke of are not explicitly written there. I think it is up to the employee to terminate or to bring it to notice to the employer that I don't think you're going as part of the agreement we had. Is there a problem? Can we renegotiate? Am I leaving? Should I leave or sue?
Okay, thank you, Tosin. Tosin, please, what's your response to number one again? Tosin, what did you?
Yes,
what
it
was
is.
your response?
Oral contract is valid. It's valid as
Okay.
long as they are put in agreement of whatever it is that they're doing.
Okay, thank you so much, Tosin. Thank you. What was our order again? We said DK Emeka Abdul Lafiz and then Peter, and I'll bring it together. Emeka, let's hear your opinion. Please go ahead.
Okay. Good evening, everyone, once again. It's funny how my name was used as the case study. I also I also went through something similar as well. But as the case may be, I think Emeka Adebayo made a smart observation and he needed to ask the right questions. Well, from what others have said, I've learned that oral contracts of employment are valid. But I would like to go to number two. I'm not sure of that number, but I've got some clarity. When an employee is employed by company A and deployed to company B to work, is the contract valid? Yes, I believe the contract is valid. If the consulting firm is the one that knows more about the employee, but sees an opportunity for the employee into another company, which is company B, I believe the contract is actually valid, moving from company A to B.
Okay, thank you so much. Emeka, it was Emeka that spoke now. Yeah, Abdullah Fiz. Emeka, thank you for that submission. Abdullah Fiz, let's hear from you. Hello, Abdullah Fiz, are you able to hear me? Seems like you haven't unmuted yourself. I'm asking you to unmute now. Okay.
Okay. Good evening, ma. Good evening, everyone.
Good evening.
As per my little experience and my opinion to question one, so if the oral contract is going to be valid, then there should be a witness, because in the course of the job, whether within 3 months or so, the employer may try to maneuver and change the agreement. So there should be a witness. And for the question two, so the contract is going to be valid because the terms and conditions are going to be on company A. And company B don't need to impose anything that is not according to the contract in which the employees sign with company with a company A. I think that is my little opinion.
Okay, thank you. Abdulaziz brought different angles to this. Third company B, you should not impose anything that is not on the contract on the employee. And then he said there has to be a witness. All right, I have to meet you. Where are you now? Okay, Etini. Was it Etini now? No. Peter John.
Okay. Good
I think you're
evening.
the
Good
last
evening.
person to speak. All right.
Yeah. Good evening. Can you hear? Yeah. Can you hear me?
Loud and clear.
Okay. It's a very good question, and it sounds very. I've been in an organization where I was also employed, and there was no letter, and I understand the implication and the dynamics. I was just laughing. I think HR professional must get this clear. It is the conduct between the employer and the employee. That is the employment relation. If you like, give letter. If you like, don't give letter. Or once they can establish that there is a contract by conduct between the two parties, and especially when the employee make inputs in the course of the business and the input leads to productivity and income for the business. Some HR professionals still take this risk, and I think it's very, very, very. So the point I'm trying to make is oral contract is valid. Whether you write the contract of employment or not, to me, is immaterial. Provided there is actual relationship between the employer and the employee, and is that I think that's that. Then the second question is, can whether an employee in company A be deployed to company B? Yeah, I think is both yes and both no. Yeah, if the company A employ the employer, if it has been stated in the agreement, or right in the process of employment, when this is the nature of your job and you can be moved from one place to the other, fine. I don't think there's any issue with that, and provided all those the conditions for moving from one place to the other have been stated, that may not really be an issue. The area of concern is if the employee is being moved from company A to company B, on what terms of agreement. Hope it is the terms of agreement that he was being engaged with in company A. It's when he gets to company B, it is that same terms of agreement that he should be working for. If he gets to company B and company B want to start introducing a new terms of agreement, then an issue will become. But moving an employee from one place to the other, that should not be an issue. So I want to leave it.
Okay, thank you so much. Who spoke now was Abdulaziz. Oh no, Peter. Thank you for that submission. Okay, so I saw some other hands up. Please put in the chat, but let me take, I think Etini and Achibong, your hands were up the longest. So I'll just take that, but I'll read, I'm coming to the chat to see what others have said in the chat. Chioma Karis, I could see your hand up. If you can put your submission in the chat, please. Etini, let's hear from you. Then Achibong, and then we'll move. Just because of our time, we still have a lot to cover. Etini, please speak.
Okay. All right. So regarding question number one, whether oral contracts of employment is valid, yes, to the extent that that is the agreement is made, but whether it is valid, it may not stand the test of time, if it is subjected to litigation, because if any disagreement is presented before the court of competent jurisdiction, the court may require an evidence, and verbal agreement or contracts, there's no evidence that will be presented before the court. So that is a serious gap if a contract is entered verbally. Then question number two, yes, is valid if an employee is hired by one organization and deployed to another, provided that there is a labor hiring agreement between the two organizations.
Okay. Thank you so much, Etini. Thank you so much.
In the case where comment. Yes.
Please go ahead. Pardon me, I didn't know you were still speaking. Are you done now? Okay, I'm unable to hear you anymore. Thank you so much, Itini. Achibong, please speak, and then I'll bring it all together. Achibong, unmute yourself and speak, please.
Okay, hi, Chinwe. Thank you for the session. So my contribution would be yes to the first question. Oral contracts are valid. And someone did speak to the conduct of the parties as a way to establish validity for such contracts. So for this case study, an example could be, so you have a driver that you've told to resume, and the driver comes and is driving you, and you let them drive you, right? So that in itself, that action establishes that there is a contract, and I think legally that can work. The second question, and also just to add to that, the organization where I work for, we also have categories of employees who we engage as casual staff, and we do not necessarily issue them contracts. So it's like for every day you come to work, you get paid. So there is not a lot of context in this case study to establish whether this can be an example of that type of employment as well. For the second question, I would say no. So if you're employed by company A, you cannot be deployed to company B in theory. But yes, if company A and company B is, say, in the same group. So if it is a group of companies, then I think the structure can allow for redeployment, in which case there would need to be an official redeployment letter specifically stating whatever terms from your first contract that might change based on this redeployment. I think that would be my submission.
All right, thank you so much, Achibong. Thank you. Thank you, everyone that have spoken. Achibong, Etini, Peter, if I missed your name, please pardon me. Angela, Uncle K, Tosin, Abdulafiz, Emeka, I think, yeah. Thank you so much. All right, so we'll check whether we'll look at them. We'll just look at the things that we've said and see if we're aligned or not. But before we do that, I'd love to see what is in the chat. Pardon me, I think when I was doing the introductory aspect, I had missed out conversations in the chat, and I realized I put things in the chat. So I really love to check the chats. Itini says, because if it's not properly handled in line with labor laws, we may end up in litigation, culminating in financial loss. Okay. I think the fear of not termination, okay, that was when they chose termination, got that. Because termination, if it's not properly handled, yes, we've established. Albert says, data protection and its legal implication. That's another heavy one, yeah. I agree. Termination, okay, all right. Let me see. Okay, these are people saying where they were joining from. Thank you for sharing. I guess Dr. Yemi asked that. It says, what if the provisions of the handbook negates the labor laws? We've established, if it negates the labor, it means that the HR person should come for this training. Dr. Yemi should invite the person for this training. If we establish that we have the ground norm, which is our constitution, and we have the other laws, other codified statutes, that the constitution is supreme. And then for the labor laws, employment laws, we said the Labor Act is supreme. And somebody now sat in his organization and now wrote policies that will contravene that of the labor law. The person, that of the Labor Act, just to answer your question, will prevail, Itini. That person should go and amend his or her policies. Okay. Yes, you're right, Emeka. Yes, attestation. Denike, oral contract. Okay, they've started answering the question now. It's a form of contract. However, employment contract should be in writing. Denike, start on the friends. Yeah. Sarah says the answer to number one is valid. Oral contract is valid. Geneca says, okay, not sure what that was. Where did that go to? Hold on. Oral contracts are valid, says Oluwashegu, but the written ones are better for clarity. I agree with you 100%. For number 2, law recognizes a triangular employment, so it is valid. Okay, thank you for sharing, Oluwashegu. Tomito says, as much as oral contract is valid, however, I believe that going with the oral contract is not deemed binding in the face of the law. So as much as possible, written contract should be encouraged. I agree, it should be encouraged. Employers of labor takes this for granted in the world of work, especially the sole proprietorship. Okay, Company A can employ and deploy to Company B, provided it's stated in the offer letter. For such employee, Temitope says. My question now is, after the employee resumes in Company B and there is misconduct, is Company B under any moral obligation to issue queries or need to refer to Company A, who gave and signed the contract? We'll come to that. Question number 2, Karish Sharma, thank you so much for dropping your message in the chat. And you share experience with us maybe in our next conversation if you have that. But thank you so much for coming back here to put this. She said question number 2 is not valid. It will be a liability for Company A. Okay. Who else? Ngofaka says oral contract of employment is valid, provided it meets the essential elements of a valid contract of offer. Acceptance, intention to create legal relation, consideration, clarity. Thank you. Nana says some organizations usually put a clause in the employment letter that the company can redeploy you to any of their businesses. Smart move. Yes, Nana, you're correct. Peter Jones says oral contracts will stand in the court as employees provide valid evidence such as company ID, pay slip, evidence of training. 100% spot on, Peter. Okay, all right. Kolawole, okay, not missing yours. Says question 1, yes, you are agreeing is valid, depending on the contract of employment, says Kolawole. Uncle K says bringing you warm greetings from the Brown Roof City. That's Ibadan. All right. Good to have you all here, and thank you so much for sharing your, experiences, your responses to this question. And to answer this question, so many of us have said that oral contract here is valid, and some people went further to even give us what can be used as the test to know whether it is valid or not. And if you've said that it is valid, I agree with you 100%. It is valid. I remember someone that spoke when we just started. The person said that the law provides that within 3 months you must give a written contract. I agree with you 100%. Oral contracts are valid, right? They are the proofs that some of us have put here to say the proof for it. This is, someone even listed them, ID card, in fact, there is a legal case that says if you can prove that, this person has paid you, right, for months, he has paid you months, 1 month, 2, you are employed by the person. And somebody else said, I think in the chat, that it will not be admissible in court. I have a variant opinion. It will be admissible in court. Yeah, it will be admissible 100% in court. What we'll preach or what we'll advise, like some people also said, is let it be written so that you can see clearly the terms and the conditions, so that there are no bloodlines, there are no patches of gray. It is black, it is white. I can see it, you can see it, and we are aligned. But if it is an oracle, I think someone gave an example of if you ask a driver to drive me, and there is a reason why this case study is framed this way, right? When I was drafting this case study, I looked at the nuances that we have in Nigeria. You can see that this case study, I have worked in an outsourcing firm. If you worked in an outsourcing firm, you see that this plays out a lot more in this kind of environment where, somebody can be, in fact, it is called a deployment letter. They give you a deployment letter, ask you to resume. They can call you this night. And you saw here where we said, let me get that. Fortunately, Chinelo has had a pre-screened pool of candidates ready for deployment. If you've worked in an outsourcing firm, you will agree with me that, outsourcing firms, they are in the business of recruiting, deploying to organizations, seconding, that's the word, right? Second them to other organizations like you're outsourced. They don't wait till an employer tells them, I need 200 people. An employer can call and say, I need 200 people in the next 3 weeks, 1 month, get me those people. They've interviewed people, they put them in the pool, they are quality candidates, they are waiting to be deployed, sort of. And then away from maybe when somebody can even ask for, ask you to deploy someone that you need, a resource, you need someone to resume. There are also some businesses, if you've managed, because I have managed it, so I can speak to it, businesses where, you're employed, how, how they employ people abroad. Let me use this works a lot more. You can relate to it. Would have, if you've seen this scenario, somebody has shared this with you abroad. There are some organizations that to employ you on their payroll and they deploy you, because how it is easier abroad is because they pay them per hour. They pay you for the work that you've done, right? So they give you a contract, and let me say it's, for instance, a call center. Somebody calls in sick today and the person is unable to come. They don't wait to say, I will now hire, go through the process of getting somebody. They already have people waiting in the pipeline that they will just call and say, we need you to, we are calling like an emergency call to come in and resume here, so and so. But let me bring it back to our Nigerian situation. So in this situation, you have maybe an employee that comes to say, sometimes the banks, they will say, we need people to be deployed in 36 states. We need this number. We need maybe tellers, this, they just share with you what they want, right? If you start the recruitment time at that, it's not like you might not be able to meet it, but you are looking at your time to fill, and they are competitors. So it pays them to have people in the pool already, right? That's why I use that. I drafted it in this instance, right? And then what now happens is that you're deployed. They give you a letter of deployment, resume here, maybe the next day, 2 days after, or something like that, right? You've gone through the process, they've screened you, and then they will now come back to give you the employment contract. That's what played out in this case, right? Because maybe they might not have the time at that point to give you that letter, but it doesn't mean that your contract is not valid. They give you that deployment. You might want to argue deployment letter, they're giving you something, yes, it is valid, but I'm saying that even if it's verbal conversation, go and resume here, it is valid. But the law says that within 3 months, by Section 7 of the Labor Act, that you must give a written contract of employment. That's the caveat. So it's not running in perpetuity. It's not, you're not running contract after 2 years, you've not, no, the law will frown at it. It says within 3 months, please give this person a verbal offer, of employment. And then these things about, because I've had mentees come to me to, maybe share their story and ask for my opinion and ask the, somebody is trying to hire someone, and then you don't give the person, maybe you tell the person, for instance, let me just use this case study and say, I'm going to pay you 100,000 as your salary. And you did not give the person contract of employment, right? And for you, that 100,000 is the gross pay. But for this person, what he has heard is the net pay. You do not write it down. This becomes ambiguous. Now, month 1, after the person was paid, the person now receives 84,000. The person asks, hold on, what is happening here? I resumed on the first day of this month. It's not like my salary is prorated. Please, HR, if you can please explain to me what has happened. HR will say, this is what we agreed now. We told you you're going to be paid 100,000. That was the net. You said 100,000 net. HR will say, no, I never said net. I said gross. And unfortunately, this was a physical interview. It was not recorded. But I meant gross when I said it. Why didn't you just write this thing down? Just to make this thing clear. So that, people are not going back and forth. The terms are clear, right? Now, to answer question 2, we answered it from 2 different ways. And it was intentional that it was drafted this way. Somebody answered, or some people answered with regards to the scenario that I gave, which is, you are employed here and you're outsourced, you're seconded. It is valid. The contract is valid. You're seconded to another organization, right? So that becomes organization B. It is a valid contract. Another person now mentioned another listener and said, if it is a group and you're sent to another subsidiary, like how a group will say sister company or something. But the person was also very, the person also puts that caveat for us to say that, but this would have been stated in your contract of employment. It would have been written down, which is also very valid, right? You have even the law, and we're going to say it shortly, recognizes that you can be working for a group of employers, that there can be a group of companies. But please, I would love to say that please state this down in the contract of employment. Do not wake up and say, oh, when she was joining, didn't you know that this company is Chinwe and Koso and Chinwe and that we have subsidiaries? No. If you've hired me for Chinwe X, please do not put me for Chinwe Y. If you did not put there in my letter that I can be deployed to Chinwe Y or any other subsidiary, as the case may be, please put that down in writing, right? So yes, if it's a group of companies, you can be sent there, but this has to be put down. So that is what we have here. Those are the what is it called now? These responses, they're just alluding to what I've said. And somebody also said in the chat that I also love that part where that's a different, a different class, really. Someone that spoke about offer, acceptance, and consideration, the parts of contract, so far as those conditions are met, right? That's another class, right? That that is valid. Trying to talk about the things that you look at when you want to check whether a contract is valid. But there was something that I wanted to highlight, but that's a different conversation. We'll not get to it in this class. And I don't know if that's saying that will mean, I'm not trying to call anybody out. Please, if you're the one that answered this, I'm not calling you out, please. I just have to put that habit, but please mute if we didn't ask you to speak, just to reduce the interference from your background. But that conversation is a conversation hanging in the offing, like it is something that is being discussed, right? And I know there are, maybe if I start that, maybe I should not start that conversation here. I'll say it at the closing of this conversation, right? But it is something that, it's, so I don't start shaking tables that we'll not be able to resolve in this class, right? But that has happened a lot. I've seen that a lot in manufacturing, in factories, and all of those things. Like I said, the labor law is very extensive. If you might sit down here to discuss today, we might not be able to exhaust and to dissect, all of those things. But it will derail me from my conversation today. But I was trying to speak to about casualization of staff, but I will have to revisit that some other time. So moving on, in the contract of employment, right? We have established here that Section 7 of the Labor Act says that within 3 months, all right, we are relying on the law. It is not, we didn't state this, it's not a policy of any organization. It is what the law has provided. Please make sure that whilst a verbal contract is valid, you can see the caveat that we put down there. But the best practice is to issue a written contract. It is not even just best practice. It is in compliance with the law that you comply with this Section 7. All right, so we've understood this and we've said, yes, this will guide us. Now, I do get, requests from colleagues, and that's fine. I'm not saying there's anything wrong with it. It is fine. I'm just saying here that, I also reach out to people for different requests. I don't know it all. I ask for different things, right? But I do get this request. Chinwe, share with me a, what do I call it now? A contract of employment. Like you asked me to share with you, like what I would term a good template of contract of employment. So the person can adopt it in his organization and start using it. I call it a blanket contract of employment, right? So the person asking this is saying it so that you will have like, you will see that, all the things that the person, all the things that it might be termed legal is encompassed in that particular contract of employment. But I'm saying that contract of employment is not exhaustive. Like you can decide the things that you want to put there, depending on the peculiarity of your business, or maybe depending on your experiences, what has happened in your organization. And you now felt like, hold on, because of this experience that we had with this last employee, it is good that we write this thing in our employment so that when somebody is joining, or the person will see it, that this is how we do X, Y, Z, and take that decision whether the person wants to join or not, right? So you can see that you can have contract of employment for some organizations. You might get one is 1 page, you might get another one is 2 pages, 3 pages, 4 pages, and all of that. I'm saying it's not extensive, it is not exhaustive. But however, Section 7 of the Labor Act already gives us the things that must be, I repeat, must be in your contract of employment. No matter how, what is it called now? How lightweighted your contract of employment is, how you want to make it, you don't want to make it bulky, okay, let them come in and see things in the handbook, or I'm going to share the handbook with them for them to see other things. These ones are the must be, right? So Section 7 listed the things, it listed these things. I didn't just put them on the slide. These things are how it was listed in Section 7. It says that these things has to be in your contract of employment. So my advice, or what I have practiced, will be that you have these things, how you have it like a template, like you're doing like a checklist, you're checking that you already have these things, right? And then you can now add other things that might be peculiar to your organization. And why I say this is that there are some things that are peculiar to some organizations that might not apply to another one. And, so let me give an instance. You may have worked in the financial service institution as a HR person. If you like, let it be that you've worked as a HR director. and you've worked for 20 years as a HR director, right, in financial services, all your experience is financial services, do you know that the day you go to work in an oil and gas sector, you find out that there are some things you've never practiced in your entire career, that you find out that there are those things that are prevalent in that industry, because each industry is unique on its own, right? And maybe, let me give another instance. You now enter the manufacturing space, for instance, and you find out that, hold on, all this while I've been practicing HR and I thought, you know, I've gotten to the apex of my career, but I've never even for one day opened the Factories Act. There is an act called the Factories Act. I don't know the provisions. I don't know what it provides, but now it should be your bread and butter because you're eating, you're drinking everything around factory and manufacturing. So you see that there is nothing like I know it all and all of those things, you know, so there might be some peculiarities in your own organization that might be unique to you that, you know, you might apply here that might be different in another one. So that being said, you see all of the things that I have here, maybe I might not be listing them out one after the other, but the name of the employers, that's that thing that I mentioned earlier, that the law recognizes that you can be employed by a group of companies, a group of employers. Section 7, you know, 1, oh, sorry, I didn't put whether it is 1 or 2, right? Because the one that says you must give the written contract within 3 months, I think that's subsection 3, right? But this states the that's this section 1 lists the different things that we must have on our contract. The name of the employer and the group of employers where applicable, the name and address of the worker and the place and date of his engagement, the nature of employment, by extension, your job description, the things that they want you to do, right? If the contract is a fixed term, the date that the contract expires. I do state, and I also have to stop here to say this, that the difference between, you know, you say someone is a permanent employee or a full-time employee or something like that, and saying that there is a contract of that your contract is so. In Nigeria, we say different things. You say somebody is a contract employee, right? You see that scenario, that case study that we gave for the case study that we gave for the last case that we looked at, you know, that outsourcing stuff, right? That case study that we gave there and said contracts, right? Sometimes people say that somebody is a contract staff because the person is seconded. That you're seconded does not mean that you're a contract staff. We say it a lot in Nigeria. This is a contract staff because the person is outsourced. I have been an outsourced employee, and I understood it firsthand that you're an outsourced employee doesn't mean that you're a contract staff. You can be a full-time employee of the outsourcing company that has outsourced you, meaning that your contract of employment does not have termination dates. Like it doesn't have an end date. You can work there in perpetuity if you want, right? So you're a permanent staff of that outsourced company, right? But in the other place, you're now seconded. So what makes an employment actually a contract is that you must have a start date and then to have an end date, right? That's what makes it a contract. Okay, so I had mentioned earlier that section 7 sub 3 was what said you should give a written contract. Please, it is section 7 sub 1. Section 7, subsection 1 that says not later than 3 months you must give that written contract. Then subsections, paragraph 1, paragraph A, B, C, D, E like this to H of that same section 1 now lists these things that we must have in our policies, right? You see where it says, so he listed all these things, the rates of the wages, method of calculating them, the appropriate period of notice to be given to each party when you want to terminate, any terms of and contract relating to the hours of work. He said all of these things. Can you see H, where the law now states any special condition of the contract? This is where the peculiarities of your own business will now come in, where your work rules will now come in as part of your own employment, you know, where, you know, this is unique to our organization. This is the way we do things here. So I will now include it in my contract of employment. The law permits that. So moving on, importance of clarity in contract of employment. You've seen, as we mentioned earlier, that, you know, this will just help you when you have this clarity, you have it written down. It serves as a legal proof of your terms and conditions. There is something for you to reference, right? the clarity in job descriptions, there is clarity there. The compensation deliverables, like the example that I gave, not thinking that the net is gross, and it's not the person's making. You know, when I also started work, I didn't know the difference between gross and net pay. It took me some time to actually know that, see, okay, let me even just use another word, that the net pay is take home. That was how I got to learn it. To know that, okay, when they tell you net pay, it means take home pay. I didn't know it. I didn't know the difference. When they say gross pay, net, I'm always wondering, confused. What are they talking about? Net, gross. So somebody can just be innocent. The person has just joined work. The person doesn't know which one is net, which one is gross. Please, it just helps us to state down those things. And then documentation ensures that each stage is handled consistently from your onboarding to offboarding, right? It will create a culture of transparency and ensure that HR, there is continuity, even when the HR or managers change rules. It will outlive you as the HR person. Imagine if you've documented everything, and not just documenting, please. I'll also stop here to say this. When we say, what is the difference, if I may ask, what is the difference between a structured organization and an organization that is not structured, right? I say this a lot in my classes. I have worked in organizations that are structured, and I have also worked in an organization that is not structured. I've been brought into an organization that was not structured, and the reason for the organization to poach me at the time was they wanted me to set up a HR department from ground up, from scratch, right? So I've seen the two parts play out, and I can say, you know, from my experience, that what makes a structured organization, it is not because the organization that is not structured does not have policies. Because how do we manage people? We manage people through, you know, policies, processes, you know, procedures, and through other people as well, the 4 Ps of managing people. But what happens is that one organization A, that is structured, they put down these policies, they put down the people to work, they put down the procedures, right? And then those things are implemented. They allow them to do the work. They implement. It is not when you want to implement something, it will now be, the MD woke up today and he's happy. He will now say, okay, just add 10,000 to everybody's salary. I'm in a good mood today. And then he wakes up tomorrow, and then maybe he's not happy with somebody. He saw somebody at the corridor. The person did not greet him. And he now said, you see that salary, that staff. I've met him twice now. He's like, he doesn't have manners. He's not respecting me. He didn't greet me. Please deduct 10,000 from his salary. You know, things are just done in an arbitrary, just, you know, not following, things just come as they come, and then you implement. And then when you even want to implement the policy, you're not also implementing the policy. You want to implement it for A, you use the policy. You use the, what is it called now? The sanction grid. You want to implement it for B, please hold on. That person's father is the friend of the MD. They are in the same club together. And then you start mincing or having double standard. That's the difference between the structured and unstructured. And you find out a lot when there are things that are not structured. You find out when employees are leaving and you're doing exit interviews, most of the time the issues are around that, you know, things that are just done as, you know, you're now seeing people quoting management is not transparent, you know, and different things like that, right? And the good thing would be for us to have the knowledge and also turn these things around. Okay, case study number 2. Let somebody volunteer to read for us again, please. A volunteer, please, to read for us. Case study number 2. Let's discuss. Tomiwa, please go for it.
Hi, good evening. So I actually raised my hand to ask a question, not to read.
Okay.
Sorry. So I witnessed something very recently where the MD gave an approval to hire a staff, and then the interview was conducted and the staff was asked to resume orally while the contract was still being prepared. And then the person resumed, worked for the first day, worked for the second day, and the MD changed his decision and was like, okay, we don't need this staff anymore. So how can an HR handle a situation like that?
Yeah, how was it communicated to the person? He said not communicated to the person, right?
No, I mean
there was no contract given to the person.
No, there was no written contract. It was an oral contract.
But when that contract was given, have they stated how it will be terminated?
No, it wasn't stated. Everything that was told to the person was, you can go ahead and resume. Your contract is going to be sent to you very soon.
Well, so we fall back on the law. Section 11 provides how we can terminate. and pay in lieu, and gives us the period. If you are employed, and we're coming to that. So not to preempt our conversation, but we're coming to that in terms of termination. So you see it in terms of termination. We're going to discuss termination in this discussion, right? But just to answer your question, we'll follow the law. The law already provides a foundation that we can follow. If you're going to terminate, if you're not giving notice, what to apply. So we come to that. I don't remember the name of the person that asked now.
It's Tomiwa. Thank you very much.
Tomiwa, yeah, thank you. Okay, who is reading for us at this point? I can see another hand up. Emeka, your hand is up. Okay, Taiwo's hand went up first. Is in the order that I went up. I don't know if Taiwo wanted to read. Pardon me, please.
Yes,
Taiwo, did you raise up your hand to read? Please go ahead. Go ahead. Emeka,
Okay.
sorry, the hand went up before yours. Okay, please go ahead.
No problem. On January 1st, 2025, the HR Director of SwiftPay FinTech Solutions, Mrs. Ngozi Okonkwo, approved the recruitment of 5 business development managers to drive strategic partnerships and revenue growth across Nigeria's digital payments ecosystem. On August 1st, 2025, 2 of the managers, Mr. Tunde Adebayo and Mr. Chijioke Nwankwo, each with over 20 years of experience in financial services and tech.
Did we lose Taiwo? Hello, Taiwo. Can you hear me, please? Excuse me, I'm unable to hear Taiwo at this point. Hello, Taiwo. Are you there? Okay. Tosin, please go ahead if you want to read for us.
Okay, ma'am. Let me just. On August 1st, 2025, 2 of the managers, Mr. Tunde Adebayo
the HR manager,
and
Mr. Ibrahim. Mr. Musa invited them into a meeting of business growth.
Okay, I was trying to meet Taiwo. Taiwo, we couldn't hear you at some point. I think your network. Please permit Tosin to go because of our time. Tosin, please go ahead.
All right,
thank you so much.
On August 1st, 2025, 2 of the managers, Mr. Tunde Adebayo and Mr. Chijioke Nwankwo, each with 20 years of experience in financial services and tech sales, approached the HR manager, Mr. Ibrahim Musa, to inquire about their confirmation letters. Mr. Musa invited them into a meeting room and explained that the head of business growth, Mrs. Biti Alabi, was dissatisfied with their performance and had placed both managers on a performance improvement plan. Additionally, their probation periods had been extended by 3 months for Mr. Chijioke and 6 months for Mr. Tunde, pending satisfactory performance. Mr. Tunde left the meeting visibly upset, stating that in his 2 decades of experience, probation periods were always capped at 6 months. Mr. Chijioke, however, noted that his previous employer, a certified Great Place to Work fintech company, had a standard probation period of 3 months. Now, aggrieved, both managers have approached you by their trusted HR advisor at another financial services firm for guidance. Advise the parties. 1. Was Mrs. Bisi Alabi justified by extending their probation periods by placing Mr. Tunde Adebayo and Mr. Chijioke Nwankwo on a performance improvement plan after their probation period? 2. What steps should Mrs. Ngozi Okonkwo, the HR director at SwiftPay, take to properly manage the probation extension and confirmation process for the business development managers? 3. According to the Nigerian Labour Act, what is the standard duration for a probation period in employment contracts?
Fantastic. Thank you so much, Tosin. Thank you so much for reading that for us. Okay, please, let's go. Let's dissect this question and, answer. Let's go this way. If you raise up your hand, you want to speak to them, just say maybe 1. This is my response to 1, 2, 3, like that. If you have all the answers, if you don't have all the answers, you can say, my response to number 1 is this. So we can take the 3 questions at a time, right? Because of our time. Pardon me, I had told Dr. Yemi that the 2 hours he gave me earlier will not be enough for me. Please, pardon me, but please stay with me. So please, who wants to answer this question for us? We are faced with a dilemma. See this dilemma or dilemma, depending on how you want to pronounce it, at SwiftPay FinTech Solutions. And this can happen to me as a HR person or even to you in your organization. If we are faced with this, what do we do? How do we help the parties here? They said advise the parties. Who wants to help us, please, to answer the question? I know the case study is loaded, but you can take any part that you want, right, and answer. Taiwo, please go for it.
Yeah, good evening, ma. Sorry for going off the other time. So, for my own response to be in line with the first question. So, in as much as there can be exception for extending probational period, it is expected that the management or whoever is in charge should communicate it to the employees. I'll reference back to the statement you made earlier about structured and unstructured organization. So this actually speaks of an organization that is unstructured because of the lack of transparency. Thank you.
Thank you so much. Taiwo's submission, yes, you can give the probation, but please communicate this to the employee, that this is very important. Thank you so much, Taiwo. Archibong, your turn now.
Thanks. I was going to put down my hands because Taiwo basically said about the same thing I wanted to say. So yeah, okay. If I'm imagining that the contract that was issued to them probably had a definition of what the probation period was, and if it had expired, and there was an internal conversation around PIP, then it should have been duly communicated.
Okay, Archibong is alluding to Taiwo's submission. He said that yes, we can, extend this probation, but please let's communicate it as HR professionals. Okay, let's hear from Peter. Your turn now, Peter.
Okay, my position is yes, there's nothing wrong in extending probation, but the manager waiting till the end of the probation period before he's not informing them, I feel that is wrong. I'm reacting to question 1. The probation period is for 6 months. The probation period is for 6 months. If you, after 3 months, you put there should be a mid-review. And after the mid-review, then at the 6 months, you review those who are good, you are keeping those who are not good, you let them go. It's not that you wait for the 6 months exactly. I think these are just employers feel that they are smart, trying to take advantage of employee and explore the weaknesses in our situation. Then the second one, I will just be brief about the second one, the point 2, about how to manage the PIP. That is, I don't know, I think I read it or somewhere where you can't put a gun in the head of an employee and expect him to perform. So managing non-performance in an employee comes with a lot of emotional intelligence, giving the employee that the support, like creating that psychological environment for the employee to understand that you are there to support them, not to victimize them. Because once you begin to come with threat and all manners of this, the employee will be agitated, so he will not be free. So the approach, the psychological support for employee at managing the probation, identifying the issue. What are the issues? This non-performance, what's the cause? What should I do? Is it knowledge? Is it supervisory? Is it lack of understanding? So actually identifying the problem and doing the right intervention. That is Then the last one, we talked about the Nigerian Labour Act. Can I remember? But what I just know is that I think most organizations, the practice is 3-6 months. But I know of recent, you can correct me if I'm wrong, that the court has actually plays like and as a stop organization from extending the probation period. As in extending it, if you say probation period is 6 months, so as 6 months you have to, if you are not confirming, let the employee go. But the probation period depends on, because in my opinion, that probation period is a training period. There's a particular thing the organization wants the employee to learn. So if 3 months is the best time, that's okay. Within 3 months, I think this person should have known this basic before we can accept him. So probation period should depends on the relationship between what the business wants the employee to acquaint themselves with before they finally accept him as a full member.
Okay, thank you so much, Peter. Peter's response was quite loaded. He attempted the 3 questions, right? Thank you. So Peter said, yes, we can extend, but inform the employee. The second one, he said, in managing a probation, that if you put someone on PIP, there is a lot of emotional intelligence that you have to also apply in terms of them being able to perform. Even you as a person that is being put in PIP, it's a difficult thing to manage. And then he said, according to the Labor Act, that he thinks that the court has stopped organizations from extending. We'll see. Thank you so much, Peter, for sharing. So we'll speak to Pelatia. I hope I got your name right. Please tell me how to pronounce your name when you want to speak. And then Emeka, lastly, and then we'll bring it together. Good evening.
All right,
please go ahead.
Thank you for the opportunity. So it's Pelatia.
Pelatia. Okay, thank you. Yes. Thank you. Okay.
All right, so for the first question, the extension of probation, if it was justified, well, going by labor law, it is not justified. Now, when you are recruiting an employee, you know what you want from that employee on their job role. If they are not meeting up with what you need from them, as against the experience they purportedly have before coming into the organization, if they are not meeting up, they are not giving what you want, you let them go. If you see some potential, that's for question 2 now. If you see some potential in the employee, it's the best thing to do is confirm the staff and put the staff on performance improvement plan. PIPs are not just for people on probation. PIP is a performance development process where it could relate to any staff at all in the organization. It shouldn't just be for probationary periods. So if you see some potential in that employee, yes, they are not meeting up, but is there a potential? Yes, you can confirm their employment and place them on PIP. Then for the third question, from labor law, no, you are not supposed to extend probation. Now, it's 2 things. When you employed the staff, what level of experience were you supposed to bring in? What level of experience did you actually bring in? Those are 2 things. So if the person is not meeting up, like I said, if the person is not meeting up but has a potential, you confirm and place on PIP. If the person is not meeting up and you don't see any potential, you terminate. It's that simple. Thank you.
Thank you so much, Pelatia. Thank you. She gave us a different angle to this as well. Thank you so much. We'll bring this together. If you wanted to put your message in the chat, please always do that. Put your message in the chat if you want us to read it out. I can see Olusegun has also put his response here. Thank you so much, Olusegun. I would also love this response to this number 3. What is the standard duration period according to the Nigerian Labour Act? Can we drop it in the chat? What is the standard duration period according to the Labour Act? What period did Labour Act give us? Right? What period? There has to be a period that Labour Act gave us. What is that period? Is it 3 months? Is it 6 months? Is it more? Is it 9 months? Is it 12? What is it? What do we have in the Labour Act? This number 3, can we answer it, please? What do we have in the Labour Act? You know that we are relying a lot on Labour Act here to, set our policies right. What did the Labour Act say? It would be good for us to establish this. If you have the answer, please put it in the chat. And like I said, when we ask questions, please, we just want to learn, to share experience and learn. There is no first or second position. It is not, we are not looking for Google definition or dictionary definition. Please just feel free, please. Feel free to respond so that we can have a meaningful conversation. All right, I can see that's coming. Thank you so much, everyone that has put this in the chat. Taiwo says 6 months. Uju says 6 months. Peter says, I feel it's 6 months. Jumai says 6 months. Peter says, I feel it's 6 months. Okay, I've heard that. Hammer says 3 months for junior staff. Okay. Adenike says, I think employers are deliberate to set their provision period. Genika says 6 months. Okay, thank you so much, everyone. This has been very encouraging for us to discuss. Okay, so let's answer this question. Let's dissect this question. And I want us to answer this question by not me just speaking to it. Let's speak to it using decided cases, the position of the law, and we'll just get it once and for all and move. What is the essence of probation in the first place? It is that period that an employer wants to test the veracity now. Wants to test, I've hired you. During the interview, you wowed me. Please come on board and prove to me that you can do this work that you said you can do. All right. That's period of test to know whether you can perform on that job that you've been, called to do. Long and short, simple and short. That's what it is. Uncle K says it is not defined in the Labor Act. Thank you so much, Uncle K. That is the probation, right? The reason why, the purpose for probation, we bring this person on board. Let's just test and see if this person can do the work. If he cannot do the work, what do we do, right? It says it serves as a transition phase before confirmation of employment. Give the employee the time to determine whether the role and the organization are the right fit. This is not just for employer, it's also for employee. Employee too. When you've told somebody we do XYZ, our employee value proposition, you're just blowing it out of proportion. The person now enters day one during the orientation. In fact, the person would have seen itself from the beginning, or maybe the person did not see it. You know that onboarding is different from orientation, right? Onboarding is the process. Orientation is the ceremonial, the event itself. And maybe during the orientation, the person sits down, was like, what am I doing here? What kind of audition is this? And the person is already saying, 1 month will not even meet me here, or 2 months, I'm going to leave this organization. It can be either ways. As you're doing probation, the person can also be checking whether he wants to stay there or not. But just for the benefit of this conversation, for us to test whether this person can do the work, right? That's the probation period. And we also say that confirmation is also very important, right? Confirmation of appointment is very important because at this point, when you now say, yes, you can do this work, I've given you this letter as my employee to now continue working with us, in full time or something like that, until you no longer want to work with us and you go, or we no longer want to need your services and then we go. But see what is on my screen. It says that under the Nigerian labor law, there is no fixed statutory duration for probation. That question was, to get us thinking. It is not a trick question, but just to get us thinking for us, depending on what you are practicing now, because before, depending on how you also, maybe the first audition that you worked in, what's, you heard, what you learned and all of that, you can carry it wrong with it. And until somebody now tells you, oh, this is actually the position of the law, right? We don't know it all until we learn it. But, in practice, we see people doing maybe 3 months, 6 months and all of that. That's what organizations do. But really and truly, there is no fixed period, right? I think Uncle K said, or somebody else away from Uncle K said, it has to be agreed with both parties. I can't remember who put that now. The two parties, that means that employer, you put it in your letter. Your probation will be 6 months, and the employee you signed, I acknowledge this is okay by me, then it's binding on 2 of you. Like 2 of you, that's what you agree. If you say 3 months, okay. Somebody can say 6 months, and the employee can say, no, why do you have to wait for 6? Let's do it for 3 months. And maybe you negotiate and say, okay, 3 months, depending on what it is, right? And that's fine. But just to answer that question, the law does not provide for the duration for probation, even as of today. Both the Labor Act and decided cases, right? What decided cases have decided are things surrounding, other things surrounding probation, but we don't have yet, except maybe one was decided, maybe this week, last week, some just recently, and I'm not aware. It's possible I'm also not aware. If you are aware, please share with us, right? So we can learn of the period. But right now, the much I know, there is no fixed period. But there is a groundbreaking case. Someone put it in the chat. I think that was Shegu that put it in the chat, right? To answer question 2 now. Question 1 that actually said was, where is that our question 1? He said, was Mrs. Bisi Alabi justified by extending their probation period, right? And this question, we are very careful to ask this question because Pelataya had answered and given us another aspect of this question. So when we said this question, right, we are very careful to put this that, if you are to extend their probation, if you've gone to extend that, you put them in PIP for the sole reason of extending their probation, like you want to extend their probation. You see this case that Olusegun has told us to, and Chiamaka Wanguma, October 2024 versus Ate Group, right, is the leading case now that says that the court has said there is no room for extension of probation period in Nigeria. Before we could extend if somebody has you need somebody to, the person have not performed up to par with what you want the person to do, you could extend. But that's why that question, you see that case study, it said on January 1st, 2025, taking into cognizance that this case was decided in October 2024. So effective this year, we are no longer allowed, if I have to put that, to extend. You know that there was something Pelataya said that caught my interest, right? If you have confirmed someone, maybe, afterwards, this person's performance is still not up to par, because she was very clear when she said that performance improvement plan is not just for new hires. It can also be for other people in the organization. So it's not like you're just putting it for just these new hires, right? But if the extension is my 6 months, I resumed work, and 6 months you're meant to confirm me, you now extend again and now put me on PIP and extend my probation. That's, the law has frowned at it, right? And you know that when, maybe if things are still going well, the person is still working with you, there are no issues. The person might likely not bring any action against the organization, because when the issue comes is when you now fire that person. You now ask the person to go, and maybe after another 3 months or 6 months, you now say your performance is still not good. Please, we were asking you to go at this point. And the person now goes to bring an action against the organization, right? I am saying that that employee will win that case if that employee relies on this case. By relying on this case, the employee can prove that the courts have said that. So this is one of those judicial precedents that I mentioned, the case laws that are now what we call the locus classicus, what is now being upheld as the leading case, that probation is no longer allowed. Somebody put, I think, I like the word that Shegu used when you put it in the chat. He said, it is either you terminate or you confirm. It's not sitting on the fence and you keep extending. The person is working, keep extending. And there was something they said in this case. Okay, I think it was in the council of Federal Polytechnic. There was something they used in that case. I'll come to that. And then after that case of Chiamaka Wanguma versus Ate Group, do you know that another case have just been decided again, just yesterday, July 2025. I saw the lawyer on this case celebrating this case on LinkedIn. And then I zeroed in and read about this case, right? The case, Olukunle Adeoluwa versus I'm not so sure how this is pronounced, whether it is the Newly Juice Company Limited or Newly Juice, but let me say Newly Juice Company Limited, July 2025, this case was decided, right? There is no room for extension again. So if you're currently extending, please tell your organization, tell your management that these cases can put us, by the decision on this case, it can put us into trouble. If we ever keep extending, and maybe an employee is aggrieved and takes, and sometimes, let me also mention this, because it just dropped in my head. I said that if the employee has been in the organization and you don't terminate, the person is happy and the person continues working, it might not be the case. Because I know some decided cases, I can't remember the names of the cases now, that what was the issue in that case, what was the bone of contention in the case, was not that the organization extended their probation. No. The issue was that there were some benefits that the organization has warehoused. And they've told the employees, you will unlock these benefits when you're confirmed. So by pushing away my confirmation period and you not confirming me, so I'm meant to be confirmed. I started work in January. You're meant to confirm me in July after my 6 months probation. You did not. You now move it again to December. You're denying me those benefits. So you're not paying me those benefits. You know, you're denying me. I'm not getting. There are some decided cases today that those were the things that he was bothered on. So maybe you told me that upon confirmation, I'll give you a car. I'll give you a status car. Upon confirmation, I will increase your salary from this to this. Upon confirmation, you will be upgraded on your HMO from this plan to this plan. You know, upon different things, and then those things will be seem to be denied when you keep pushing that confirmation forward. So sometimes it might not be that the person is still in employment. Somebody can get angry and say, hold on, what is happening here? You've been extending my probation, extending it. This is like 9 months after. The person will resign on his own. You do not terminate. But the person resigns. Somebody needs to mute. David Obida, I've muted you. Please, if you're not speaking, kindly mute so that just to control the interference from our background. The person can now leave the organization and bring an action against the organization. So we have to be careful. Again, I put the caveat that the situation is different from the public service employment because they have their own provisions. You see section 020301, right? And 030202. I'm not so sure if that's the way those numbers are called. They stated clearly the duration for probation in the public service employment and their process of confirmation, right? So I put that caveat out there. So confirmation is very important. And there is this case again, the Council of Federal Polytechnic, Ede, and 7 others versus Oluwakari Johnson. In this case, this is the case. This is a groundbreaking decision that proved that if this one is trying to mention other aspects of the law for probation, if you do not confirm someone and you say maybe 6 months, after 6 months you're confirmed, and you keep quiet, HR will just ghost you. There is no confirmation, no termination, no confirmation. You just continue working, they are paying you. The law assumes that that person has been confirmed. You're due to have, like that, the law assumes that you've been confirmed, duly have been confirmed, right? And any action that the employer wants to bring upon to say that because of this, you're not, I have not given you a contract, you've not been confirmed. The employee can stand on this case to say that, I'm duly confirmed, right? And the law of extupel, there is something we call extupel. That law will stop you. Like you can no longer what's the word now? You can no longer, it stops you from denying that fact. Let me put it that way, that person has been confirmed. So by this case, the law has proven by this case law that if you do not confirm and that time has passed, that person is deemed to, that position or that role, that person is deemed to have been confirmed. Okay, so please, if you still have this in our policies, the essence of us sharing this knowledge, these cases are still new. So it's possible somebody has not heard it. It's not even up to 1 year. We are talking about October last year. We're talking about July, just two months ago. If I was not in the legal space, it's possible I don't know as well. I don't know about it, right? I might not know about it. So the reason why we keep sharing this knowledge for, there is nothing like over communication so that we just do the right things. If we do the right things, employees are happy. We have less cases. We have less people going to courts to bring the organization to court. So these are the cases. These are the decisions, that the courts gave. October 2024 and July 2025. And Chiamaka Nwanguma versus Ati Group. And hold on. Okay. I wanted to check this name because I know I do write this name wrongly. Somebody help me check, please. Is this name Chiamaka? I know I've been saying Chiamaka, but I have to confirm whether it is Chiamaka or is a different name. But it's Nwanguma versus Ati Industries Limited. But I think I've written this name wrongly somewhere. Just that's our middle name. Okay, so we've established the confirmation of appointment, and we said please do not extend probation anymore. That's the essence that we're here. This is our third case study. The third one, and then after this is remaining one. The third for as much as the time will permit us today. So this is the third case study. Please let's have a volunteer to read for us. Someone please read for us. DK Emeka, please go for it.
Okay, thank you very much for the opportunity. The case study 3, the curious case of Emmanuel's exit from Bitwave Technologies. Emmanuel had been working for 8 months as a junior systems analyst at Bitwave Technologies, a mid-sized IT consulting firm based in Victoria Island, Lagos. He was known for his quiet diligence and willingness to learn, though he had struggled occasionally with punctuality. Twice he had arrived late to work due to Lagos traffic and was verbally warned by his team lead. No formal query, no written documentation, just a brief scolding and a reminder to be more professional. Then came Friday evening, the time most employees wind down and look forward to the weekend. At 7:42 p.m., Emmanuel's phone buzzed. It was a WhatsApp message from Mrs. Ronke Balogun, the firm's HR manager. Hi, Emmanuel. We've reviewed your performance and lateness issues. Management has decided to terminate your employment. You don't need to come in on Monday. Thanks. No termination letter, no prior notice, no payment in lieu of notice, just a short message that ended his job like a cancelled appointment. Emmanuel was stunned. He had no idea this was coming. He had not received any formal disciplinary action, and there was no mention notice, pay, or even a handover process. Now he's asking, was this legal? What should I do? As a HR professional, advise Emmanuel.
Thank you so much, Emeka. Thank you. Thank you so much for that. Please, who is advising Emmanuel? Emmanuel could have been you. It could have been me. You know, we get to the office, God forbid, and then we get this kind of message. Oh, he didn't even get to the office. They said sent it via WhatsApp. It could have just happened to anyone. Please, let's advise Emmanuel. Who can help us to advise Emmanuel? I actually prefer when people speak, so we get engaged speaking. But if you can also put your message in the chat. And I could see that we had some other responses the last time, you know, but yeah, so we've spoken to this, but thank you so much everyone that have put their message in the chat. Abdullah, I can see the probationary period for fresh graduates is 12 months, right? I can see all of that, but yes. Okay, so Uncle K, please, Uncle K to the rescue.
All right, thank you very much for this very insightful, very enlightening, very educating presentation. I think somebody should just tell Emmanuel that he's a rich man going forward. If the HR does, he has just hammered, he has just made money, you know, of his organization, because that is the height of unprofessional conduct that any HR can actually perform on the job. No formal query, no written anything against it, just sent a WhatsApp message. It is not done. The guy should just go to court and just wait for his check to come to his account. He's a rich man. To just put it plainly. I can begin to now dissect what is wrong there, but where the ball will land is completely in his favor. Okay, the HR was completely unprofessional. Even if you do any verbal reprimanding of Emmanuel for coming in twice, that is not formal. It is just trying to encourage him to come early. If you think it has become habitual for him, you put it in writing and you document it. Okay, and you begin to put all those things and then let him know that, okay, these are formal complaints or notice about you that you need to improve upon. And if you're going to give a query, you don't even terminate anyone without giving the person a query. You give query and give room for fair hearing. Let the person give a response. There's no query in this matter. No, he wasn't even allowed to give, he wasn't given any fair hearing. He was not allowed to make any some form of defense for himself. And then the mode of termination is completely unprofessional. You don't even tell somebody, you don't write that you have reviewed performance. Who did you communicate to that you are reviewing the performance? Who did you communicate to? Nothing. And then you review my performance behind me, and even the lateness they're talking about, it wasn't documented. I can't deny it. That never happened. Okay. And then say the management has decided to terminate. Even using that word terminate, gone, it's another thing for me to cash out on. So in every way, Emmanuel is a rich man. Thank you.
Thank you so much, Uncle K. Uncle K is speaking like a Nigerian that we love money on this side, right? He said Emmanuel should consider himself a rich man, but that's just on a lighter note. But coming to the facts of the case, Uncle K broke down, right, the things that have gone wrong here. Let's hear from Pelletire, and then we'll see what is on the, some people have been putting things in the chat as well. Thank you so much if you've done that, right? But I also want to ask this question. Please, this case study, is this far-fetched? Have you ever heard of something like this? You can drop in the chat. Is this something that can happen in a Nigerian organization, right? So that, are we really building castles in there? Are you just imagining things, or is this thing real? I have seen this before, right? That's why I use this as a case study. So I'm asking, is this real? Is it just, am I the only one that have seen something like this? Drop in the chat. Have you ever seen something like this? That they send a message, text message, and say, don't come in tomorrow. No, don't come in tomorrow. Your services are no longer required. Has anyone seen this kind of this thing, right? You see this WhatsApp one? I've seen this WhatsApp one. I have seen something like this, right? Pelletire, over to you. Please speak.
Okay, so I was just typing in the box. All right, so this is a clear case of unlawful termination. There is no debate. There is absolutely no debate. Firstly, the method of communication was clearly unethical. Secondly, there was no disciplinary procedure followed. The disciplinary procedure was completely skipped. Then you tell a staff that you are terminating, and you said it's because of the performance and the issue of lateness. But meanwhile, in the whole process, nothing was mentioned about the performance. Now, as HR, what did you do to see how you can help this staff curb the issue of lateness? We can also do a PIP on lateness, on conduct. It doesn't have to be mainly on work performance or work responsibilities. It can also come with attitudes. You can also put a staff on PIP when it comes to habits, characters. What did you do as HR to help this person curb lateness? If you had a one-on-one with this employee and the person told you, okay, I live in an area where I'm coming with the traffic, not against the traffic, what did you do? What did you do? How did you try to help? All right, that's by the way. Now, the HR didn't do his job in any way at all. In fact, the job was not even done as HR. Then the management said terminate. What is your job as an HR manager in an organization if you cannot advise? If you cannot advise management, what are you doing in that organization? So that's where it comes to advising. You bring up labor laws, you show them practical examples of cases that have been judged before. Now you make references and let them know that, okay, these are other ways in which we could handle this situation other than terminating. If they refuse and insist there must be a termination, please terminate appropriately. You give adequate notice, pay the person their severance benefits, and make sure that everything is done correctly. So this is just this HR person. I don't know. We need to find that HR.
And find yes, this HR, find her or find him.
And yes, I've been in this kind of situation. In fact, my employment was terminated because I advised management against unlawful termination. Well, I was glad to go because the whole unethical practices in the organization was choking me. So I was glad to go, actually.
Okay, thank you so much, Pelletire. I'm sorry you've had that experience. Sorry about your experience. Okay, so Pelletire has also given us her own facts, which I agree 100% with. Uncle K has given hits 100%. I agree, like 110%. I agree with all the submissions, right? Let me see what's in the chat. What do we have here in the chat? So people are alluding to this, that yes, this kind of thing can happen, right? It is so real, says Jumai. Etienne says yes, this can happen. Stella says this happens a lot, says Obi. You know, Okay, Pelata has shared this with us. Uncle K said this is also saying this has happened to him. Sorry about that experience. Emeka says sure it can happen. Okay, because of league. Okay, Emeka is speaking to the traffic. Yeah. Um. Abdullahi says it happens so mostly in an unstructured organization. Yes, owner managed organizations. Yes, you're correct. I have seen it a lot, says Sarah. I've also seen a situation where they told the security personnel not to open gates for employee. Wow, because they don't need him anymore. Oh my Lord. Most of these things happen because most employers just need to go to or go home. Yeah. Taking the employee to court would be a waste of time, resources. I feel you're correct. HR personnel most of the time advises, but mostly in one man's business hardly listens to HR. Who put this submission? Thank you so much, Sarah, for sharing. 100%. I align with you. It happens every day, says Friday. There are another twist today says some of the HR managers we have lately are too scared of management and can't even give advice to management, even when it's obvious that the management has taken a wrong move. So where you're spitting the facts. When HR people are seen as puppets in the hands of management, management just says, do this, just execute. They're just that's not the word I wanted to say, but that's not the word that came to my head. It's not the word because that one will mean something else, right? But where they are just executing what the others from the management, it's not really advising. That's not the right thing to do or the right way to practice our profession. And I've seen instances, right? But you may argue with me. You might bring opinions, right? Like was it Sarah that said that people need to get to work and all of that? The reason why I've also seen instances where HR managers, they left organizations, they left on their own because of these things. When they can't take the things happening that they don't want to be the HR people in that organization that signed those things or were in the organization where those things are practiced. Because guess what? When there are cases, right, against the organization, there are some cases that when it borders on some things, you can be called in, you can be joined to a case, right? Even though in legal principle, right, who they would have sued is the organization itself, because the organization is the legal entity that can be sued and it can sue, right? But coming to maybe as a witness or giving your own facts or saying what happened, and don't be shocked, sometimes the management can deny HR. They say HR did not advise us on this. HR never said this. We didn't even know that this is wrong. Meanwhile, that's why it's also good for HR to document those things. Send a mail to say you're advising on this or this is your position or something. I've seen instances where people left, right? You might want to argue like, oh, maybe that person doesn't need the job, or so it can be other things I want to argue about. I've seen people that, there is a difference between people are working somewhere and some things are practiced and those things are things that, for the lack of a better word, I don't know how to put it now. Maybe things that you can get by, like maybe maybe they have not had someone that came to enforce it. Let me put it this way. But there are some things that, when those things are now eroding your own values as human, right? You see people that they can't stand this. They leave such organizations. So I'm just saying that yes, these things happen. DK Amaga says, I believe the manager don't know what to do, as that's why he's asking what he should do. Yes, he doesn't know. That's why he asks us to help him. He might not might not be a rich man if he doesn't use his right, but as a HR professional, a good life can make him. Oh yes, you are correct. Yeah. Sometimes that organizations also get away with these things is because nobody has taken the action to court. When just like Sarah said, you look at the cost, they weigh it and say, they let them move on. Sometimes it's not just on the side of the employee. Sometimes employees can do their own too. That's a different conversation, another class entirely. The things, it's not just unfair labor practice on the side of the employer. There can be things that employees will also do. You hear it, you'll be saying somebody did this thing, right? And sometimes the employers, they also leave them because they want to, sometimes they take an action just to set precedent, just to deter people from doing that, right? And sometimes they might just say, let's leave it, let's not proceed with this, because they don't want to keep going to court with that person. And then there was something Pelataya mentioned. He said you can also correct the person. So we looked at the legal aspects of this, but just looking at the other aspect that is not, there are legal issues here. She was trying to talk about performance management, trying to manage the person, right? Why didn't you also correct that thing that we say? can I remember it now? Positive reinforcement. When you want to correct someone, you can say, do this, and when you're trying something like lateness is something that you can. I think there is negative reinforcement, there is positive reinforcement. I can't remember I think there is even a third one. I can't remember them now. Pardon me. But yes, I agree with you, right? So let's now, in answering this question, we'll have to now see the different aspects of law that this thing border on. Like Pelataya said, this is a clear-cut case of wrongful termination. Can you see the 1, 2, 3, third paragraph says no termination letter, no prior notice, no payment in lieu of notice, just a short message that ended his job like that with a canceled appointment. And we'll come to it to see the reason, the difference between a dismissal. This person was dismissed, though. This is dismissal. This person was dismissed. Because if you do not give somebody prior notice, you do not pay the person in lieu, you have just dismissed the person. So we'll see the difference as well in terms of, when we say termination is what is it called? An umbrella word. An employee can terminate a contract, because it's when we now start breaking things down legally, we start using these terms. When you say an employer, when we say in Nigeria, and somebody's appointment has been terminated, we always think about, okay, if you say it has been terminated, employer, but if you say termination of employment, it can be either ways. It can be employer, it can be employee. If it's employee, you have terminated your contract by resignation. If it's an employer, you have terminated by different ways, which you're going to see in the next slide. So let's answer this question using the position of the law, the decision, the provisions of the law, and if any, maybe case laws, right? So this is talking about managing employees' exits legally. An employee's exit refers to the formal process through which an employee's employment relationship with an organization comes to an end. Well, how will it come to an end? Will it be something that will be done in a legal way that the law recognizes, or the way that the law will frown at? What we want to run away from as HR professionals, at least they have taken training, right? Warren Pelataya was saying, we need to find that HR, find her for me. Let's bring the HR person to Dr. Lee Emi's class to say, come and take this course. You need to take this course so that you see that what you're doing is wrong, right? We want to always stand on the good side of the law and put our organization in the good light. So how can you terminate? How can employees' appointments end? It can be voluntary, by resignation. I choose not to work again with this organization and I resign. And also, it can also be voluntary by retirement. I must put a caveat here. This is my own school of thought, right? You might argue with me, or if you don't find it in a textbook like this, but I know that someone can retire voluntarily. My mother retired voluntarily. She didn't want to work again at a particular time. She wanted to just go do her own thing, right? Not retire. Not resign. She retired. Like, you now call upon for your pension to start being paid, right? Without you attaining age 60 or something. So by my school of thought, yes, you can retire voluntarily. And then there is involuntary way of termination, which is by retirement as well. You've reached 60. They can't, harbor you again by the provisions of what governs that particular institute, because it can be different. I know that in the universities or in the education system, I think professors now, either 70, someone correct me if I'm wrong, you can put it in the chat, either 70 or 75 professors are allowed to continue facilitating. I can't remember now. If you know it, please put it in the chat. Let's learn together. I think their retirement age is now 7, because they are just an embodiment of knowledge that you can't just let them go at 60. Why are they staying home at 6? Let them just continue to impact the lives of people, teaching a lot, all of that for professors or in the education sector. So, but by retirement, you can see in other organizations, at a particular age, it's not by you've reached that age, so you have to go. Termination by the one that we normally say, they no longer need your services, or for some other reasons, the person's appointment is terminated. Then by redundancy, maybe the organization is now going down. They are maybe they face some kind of issues. They are or maybe they even diverse teacher. They've divested. They're no longer doing that part of the business. Uncle K, thank you. He says 70, right? Thanks so much, Uncle K. And they divest and redundancy, or like we can see, you know, we talk about business continuity plan. I remember when I was in insurance, I used to, you know, sell that insurance to companies, and I didn't see it come to play until COVID hit, right? And we saw that organizations that did not have business continuity plan, it was a necessity, because then, and just to put out, you know what I said about the contracts. You might think you have, my own contract doesn't encompass everything. There is no one contract today that I think that contract is, if you like, let it be a judge that wrote that contract for you, or a lawyer that wrote it for you. Some things can come up, and I'll prove it to you that before COVID-19, right, we were thinking, I worked in an organization where we are doing that, what they call it now. You know, when you want to, I've forgotten the name, but it's business continuity plan, the things that you now do. When assuming what you normally do then is, just imagine that you come to work today and our head office is no more, like it's been burnt down, or there was flood, we couldn't enter the office. What do? We set up like a call tree. This person calls this person, this person calls this person, this person calls this person. You start doing XYZ. And in that organization, we start practicing it out. The enterprise risk management in that organization was so profound. Like they practiced this thing. So we start making those calls and working contingency plan. Thank you so much, Etini. We start doing those things that we're supposed to do, right? What we ever put in those emails and all those things, flood and fire. Nobody saw pandemic coming until COVID-19 hit, right? And even as HR professional, because I remember that I was redrafting with, you know, some lawyers, then redrafting contracts, redrafting on end. We had to put that clause, force majeure, right? That there can be force majeure that can, without you being the one stopping it or the employer, these things can happen. So you might think that, oh, I have a fantastic blanket contract of employment, and tomorrow it might be that it is not actually, right? So thank you so much, 18. Yeah. So so it can be that I've lost my trail of thought. I can't remember why I brought up that thing, but redundancy and then dismissal, right? Someone might now want to ask, what's the difference between dismissal and termination? The difference between dismissal and termination, right? What's the difference? If you're dismissed, like we saw Emmanuel being dismissed in that organization, it's like telling somebody to go like a thief, like a criminal. Nothing is paid to you, just leave. You just leave like that, right? There is no, you're asked to go immediately. There is no, and most times it's maybe for gross misconduct. You know, you've gone against what the organization has provided or something, like somebody fights in an organization, or you've stolen and proven. I have to put that caveat too. Stolen, fraud, and the evidence has proven, because before then it's alleged that that person has done those things. You have to have your evidence, have to have written documentation, and we're coming to that. All the things that happen to Emmanuel, right? Because if you get to court, that's what the court will ask you, right? The person is dismissed. But if it's termination, you terminate, you give the person notice, you know, on when it will now come to end, or if you're not following it, you're not also paying the person in lieu. That's you're terminating the person's contract. But summary dismissal, like a thief, like you've done something and they say go, you're entitled, you lose everything, right? Okay, so that takes us the other aspects of it, because we are talking about managing employees exit legally. The other part of it is now termination of employment, right? And we are saying that these are the 6 ways of terminating a contract. By notice, right, which the law upheld in Section 11 of the Labor Act that we're going to see. I no longer want to do this. I give you notice, you know, this is my notice period. I'll leave at this end. Whether it is the employer on the employee or the employee, by notice, gone, no longer sufficient, or you're no longer doing the business with them. By performance, right? And by this performance, it doesn't mean your performance at work. It doesn't mean, you know, the performance, I haven't done well and all of that. No, by performance of the contract. So you give me a 6 months contract, January 1st to end June 30th. By June 30th, automatically that contract has elapsed, extinguished, expired. It has been terminated by performance. I've done that thing that you want me to do, and it has been terminated. You did not terminate my appointment. I didn't terminate it. It has ended. It has expired. By death, I don't need to explain this. Termination by summary dismissal. So I've mentioned this earlier, right? Somebody was asked to go because of maybe gross misconduct and all of that. And then by operation of the law. By operation of the law, there can be different scenarios, right? Force majeure can come in here. There is a case around, I think Brown and something. Brown and, I can't remember the name of the other party in that case. By war, terminated that case. Terminated their employment, right? Or maybe because of winding down, you know how a company can go bankrupt, and there is a solution. The solution of that company, the court asks that company be wound down, right? So by operation of the law, if you're dead, the company is no longer existing, so you've quote unquote lost your employment. Uncle K, your hand is up. Please unmute yourself and speak. Ask your question.
Okay, thank you so much. This matter of termination you're talking about, I would like to ask a question and give you a good background to the question so that you can know how to actually answer it appropriately. There's this organization, an international organization that runs contract for all the staff. All staff are on contract, and each contract is a renewable contract. Fixed term contract of 2, 3 years, 5 years, as the case may be, depending on some conditions. But usually it's a renewable contract. And what I mean by renewable contract is that after 2 years, you are renewed, maybe for another 3 years, and 3 years, and 3 years. And you could be doing that for the next 30 years, 35 years till you retire, okay? As long as there's need for that position. So there was this employee in HR who is on the renewable contract, and the employee's contract would not be renewed. The employee was not told, and it was at probably an hour before the close of business of work on the last day of that contract, right, that the employee was told that his contract will not be renewed. And the employee was actually asking, what is the update on my contract? He wasn't told. Just as they've been doing before, sometimes when the contract expires, the employee will be told, continue your work. We usually renew. So the employee relied on that previous contract status, which has always been renewed, but was not told that the last one that got before close of business. All right. So now
I'm losing you.
The employee was told just 1 hour after that. Your contract will not be renewed, and you have to, drop every official document with you and everything. We would send your non-renewal to you, but please, you have to exit the organization right away. So in that case, what can the employee do, or what is the best?
Okay, I'm unable to hear you anymore, but I think I get a sense of what you're trying to ask, right? So when you started, I wanted to put this question in the parking lot, right? The reason is, I forgot to put this caveat when we were starting, in terms of, so if you want to establish maybe a principle of law, yes, you can ask those questions. I can just answer because it's straightforward. But if it's the peculiarity of a particular case, like something that has to do in an organization, I'll just beg the person, if you can please stay with me till the end, and then we analyze this just so that we cover the other things and because of time. But let me speak to this. So I also love how you asked the question. So if your question had been, is the organization right or wrong, I might not be able to answer you right now, because there are different circumstances surrounding different cases. And if you hear from one party, you'll not be doing justice to that case. You need to hear from the different parties to get a sense of the entire, the whole circumstances surrounding that case for you to be able to speak, right? But hearing you now, I can just see some principles of law that you just, you were just dropping as you were mentioning those things, right? One is implied contract, right? Something that has been done by conduct. But let me start from the beginning. First, that kind of contract is what we call rolling contract or renewable contract, right? And that employment has been terminated by performance. That employment has been extinguished. It has ended, right? That person has come to the end of his contract. But there was something you said. You said in the past, that is an implied contract now, that they will tell the person, sometimes they don't give the person contracts on the last end of the the last day that it would have been terminated and say, continue working. That will still, now will still give you your this thing. So the person can rely on it and say, they've always told me that, right? But the question here will now be, did they tell this person this in this instance to continue working, and we'll give it to the person? It's not a question for you to answer now, right? But I'm just saying, just reflecting on the things that you've mentioned. That is one. Now, two, there is a clause that employers will always put on rolling contracts to protect themselves. And once that thing is reviewed by a lawyer, the lawyer will always see that that contract is written that way, that your contract is renewable. It will not state that will be renewed on the last day. It will always state renewable. There was an article I wrote on this, right? And I published it on LinkedIn, that it will be renewable. If you use that clause, right? What you're trying to do here is to stay on the good side of the law. I said renewable, that's like maybe, maybe not. So the test will be here now that on the last day of that working day, did they tell this person, like they usually do, that it will be renewed? This is not for you to answer, but this is for you to reflect on, right? If this was not said, the contract has ended. But I also want to, even though this will derail my thoughts, right? Sorry, not my thoughts, but this class, but it's not for us to discuss here. But there is also another conversation on what we call contract of service and contract for service. Contract of service is, and there is a test. There are different tests that you can deploy to know whether a contract is actually contract of service, that is employer-employee relationship, or contract for service. Because if it is contract for service, you're working for me as a contractor, as an independent contractor, which the lawyer or the HR person would have carefully defined on that contract of employment to try to keep them on the good side of the law. But just to be so that I don't get into another class, right? But to answer this question, those things I mentioned, right, they will, and I'm just saying again that I might not be able to say right or wrong because there might be other facts of the case that I'm missing because I've just heard from one person, right? But I hope this helps to an extent, Uncle K. But if not, I don't mind, we can discuss this afterwards. I'll drop my contact. You can take this conversation after the class, right? But because of time, please permit me to move on at this point. Okay. So I've been talking about Section 11 ever since, and I'm saying Section 11 provides the minimum requirement, minimum notice period that you can give, right? Now, I want to answer that question. There was somebody that asked me the question that they told somebody to resume work within 3 days or something, I'll be 1 week. They did not give this person contract and told the person to go. Your service is no longer required. How can the HR, treat this? This is how the HR can treat this. Section 11 already says that if the person has worked under 3 months, 1 day notice is required. If the person has worked under 3 months and between 3 months and 2 years, 1 week notice is required. This is the law, not me. Section 11 stating this. Between 2 and 5 years, that's in between 2 years and 5 years, right? 2 weeks notice is required, like that. All right. And then you can see a decided case here in Oladuni versus Wando PLC, decided in August 2025, where the court held that this case just dropped. I think I saw this case in one of the HR platforms that I belong to, and I zeroed in to go and read about this case, the facts of this case, right? But this case has to do with failing to give, terminating. You did not give notice. You did not also pay in lieu, which is one of the things that take employers to court. That's where employees take the employers to court, right? This will be wrongful termination if you do this. Like what happened? Do remember that we had a case study that I'm answering. I'm trying to answer, but I do not want to answer it just straight line. I want to use the position of the law and position of the law and some sections and decided cases to answer it. So we are still speaking to Emmanuel's case, and we've confirmed that it was a wrongful termination based on this fact that we've stated. All right. So unlawful termination will be when you dismiss someone or you lay somebody off due to breach of contract, for instance, without due process. And you saw in Emmanuel's case, they said there they did not give query. They did not say, I think, was there even verbal warning? I can't remember now. But I also want to stop here to say that sometimes what people think, and this to employees now, maybe not HR professionals, will now think that when you give me a query, that query is the punishment. Query is not the punishment. The law, by Section 36 of the 1999 Constitution, as amended, already stated that you must give fair hearing. And you see, Section 36 of the 1999 Constitution, it has so many children. That's like we say, it has like, what is it called now? Subsections. And do you know that for each subsection, like, I can never forget that section, right? I remember then, you know, when you're analyzing this section, for each subsection, there is a case to tell you how serious that thing is. 36 subsection 1, there is a case. With the ones that have the paragraph, like for each one, there is a decided case on each of those sections to tell you that fair hearing is something so big, so like I can't even equate it. Like the law frowns that when you ask somebody to go without giving the person fair hearing. If somebody has done something, disciplinary action, you're trying to treat it and you don't hear from the person, it's called all the utterance pattern. Let the other party speak. Hear from the other party. That's the Latin maxim is what I just gave, right? You must hear from them. When you get to the court, what the court will ask you is, what did the person say when you ask this person? Because you don't just wake up and tell somebody to go. If the person is aggrieved and take it, the court will ask you. And that's why you also said in that case, there was no documentation, did not document. Query is actually to hear the other person, to give room for the other person to, even when I catch you now as HR person, I saw you on the staircase, you slapped somebody and you were beating somebody, CCTV camera caught you. I will still issue you a query and ask you, please, on Tuesday, so and so, it was observed that you were fighting on so and so. Please give a reason why disciplinary action will not be taken against you. Then you now go and state it for me in writing. And maybe the person will admit and say, I'm sorry, it was the devil, or the person can deny. But that query in itself is a valid document that you need to protect your organization, you know, against all of those things. To say that, oh, we actually heard from him. There is a documentation. This is what the person has said, right? But when you do not give it and just terminate and the person goes, that's when the law will hold it against you. That any damages that the person has claimed, oh, mental health, oh, this one, psychological, this thing, I could not feed my family for 2 days, 2 months, I could not find a job, and all the hardship you've put me in, the person might win that case in most cases, right? Because you didn't give that fair hearing. In violation of the statutory or constitutional protections, that's we're still talking about unlawful termination. It will be unlawful when you go against the statutes or constitutional protection, like Section 36 of the 1999 Constitution, without giving, which says that you should give fair hearing, and you do not give that fair hearing, right? And these are examples of unlawful termination. You didn't give notice, like we saw in Emmanuel's case, right? Dismissal without fair hearing, like I've said, or termination based on discrimination, pregnancy, religion, and all of those things, right? So these are unlawful terminations. So we are coming towards the end. Please stay with me. So termination of employment, these are the legal risks for us to avoid as HR professionals. Please always follow due process, right? Let there be a disciplinary committee. Let somebody hear. If there are witnesses, let them come and give their own part of this thing. If they have to write, let them write. And also, please put a sanction grid that helps you, right, as a HR professional. Let it not be when something has happened, you now sit in the committee and you're deciding, what are we going to do? Should we give 2 weeks suspension? Should we give this? What are we going to do? And all of those things. Not that you might not have cases that you've not covered. Those things happen. It has happened to me as well. Like those things are in your blind spots. Like you've drafted a policy. You've even drafted, like you've gone around trying to draft policies. You know, you've looked at different scenarios. If this happens, I'll do this. If this happens, and you've drafted a policy that I think is watertight. It has happened to me. Something happened in the organization and we found out that our policy did not cover it too. So what are we going to do in this instance, right? So that committee is also very important, that you can now sit and say, if we have this sanction as this, close to this, can we do this, right? So it's not, I'm trying to say that there can be instances where you did not envisage that something is coming and then that happens. But let there be that you have a sanction grid in the first instance that you're using so that there are no double standards. You know, people already know, they've read it and all of those things. Some of the legal risks to avoid also discrimination on the grounds of being biased, failure to pay final entitlements, ignoring employees' right to appeal or be heard, right? When you put it there, especially I've not seen it in terms of worked, right? But I've heard that, you know, this applies in places where they have union as well, right? Maybe there is rights when the person will have a right to appeal to say, okay, I'm appealing on this decision. Can this so and so be done? And maybe you've also stated in your policy. Please give them that right. And then best practice will be to always follow contract terms and Labor Act rules. We've established this. Document every step. Very important. That documentation. Conduct exits professionally and respectfully. Very, very important. You see that exit interview. But exit interview does not operate in isolation. That's a discussion for a different day, right? Because sometimes things you did not do when they were still in the organization, you see when they are leaving that you now want to ask them during exit interview. They will not tell you because all this time they've been saying it, nothing was done. Now they want to leave and you're asking them XY. They'll just keep mute. Everything is fine. Why are you leaving? Family decision. I'm moving home or something. They will just tell you things that's every other thing, but not what you want to hear. To maintain fairness and all of that, and seek legal advice in complex or sensitive exit cases. I'll also stop here to say, always seek legal advice. The good HR person is that professional that has the lawyer as his or her friend. If you have a legal thing in your organization, I'm saying it because not all organizations have the legal team. Please make them your friend. Work hand in hand with them, not just for friendship, but like your work revolves around theirs, right? When you've drafted policy, let them review and use the legal lens to look at it, and tell you when those things, when it is not watertight, and let them make it, that's tight, right? If your organization does not also have an external lawyer that guides you, because guess what? If those things are not there, you can you might think even the lawyers seek opinion from each other now. I've established it before. One lawyer can have one view, another lawyer can have another view. Even like the ones that I discussed with, the lawyers in my organization, we have varying opinions at times, and then we agree to disagree. So it doesn't mean that you're going to ask somebody, it doesn't mean that, maybe I don't know it. No, the person can be seeing something that you're not seeing. Talk more of when the person has a legal background. Okay, so for this quiz, please drop in the chat. What is the total number of annual leave days provided by the Labor Act? Drop in the chat. Drop the number in the chat. What is the total number of annual leave days provided by the Labor Act? Drop in the chat. What is that number? Let me see the number. What is the number? The total, that's the one that the law recognizes. Leave days. Drop in the chat, please. Drop in the chat. What is the total number of annual leave days as provided by the Labor Act? What is it? Taro says 6 days for each 12 months. Okay. Sarah says minimum of 6 days. Did I see for infants? Who is laughing now? Check that. Maybe is it what they call that, an autocorrect or something? Would you say
underage? So
okay, are you saying because the underage that the law recognizes is apprenticeship? Apprenticeship. Away from apprenticeship, I do not know. Maybe there is one, but I do not know of any other form of employment away from apprenticeship that the law recognizes as working below 18. But okay, but let me not. That might not be the basis of this. What is it called now? Conversation. Would you say 30 days? Deborah says 14 days. Hammer says 28 days. Sarah says 6 days for adults from the age 12 days. Okay, let me ask the second question. How many days would you have worked before you're entitled to the annual leave days as stated in the Labor Act? How many days would you have worked before you start going for this leave? Let's check. This is checks that we are doing. So we see that we know the right now, we are doing the right thing. That's just the basis of this. Jumai says 12 months. 12 months says Taiwo. 1 year says Hammer. Beth says 12 months. Sarah says 180 days. 12 months says Genika. 12 months says Williams. Okay, keep it coming. DK says, Amaka says 12 months. 3 to 6 months says Deborah after confirmation. All right, let's see who got it right. Let's see who got it right. The total number of leave days that the law provides is actually 6 working days. What a short time, what a short period. I am aggrieved as an employee for this number of days. Like, I feel like, why should the law even put this in the first? If you like, let it be that you develop this contract in 1900. Why should you think that somebody will work for the whole year and then you are entitled 6 days? Like, seriously, you want the person to faint while the person is working? It is part of the law that needs to be reviewed like yesterday. It is so short, 6 working days, and you would have worked. See, the second question said you'd have worked for 12 months continuous service. Now, you see this number one, I do not know of any organization today. Maybe you know. It's possible somebody on this call knows any organization that gives 6 days as leave days. Because what the law has provided is the minimum requirement. So you can do above, because in this instance is to enhance, for you to be able to attract, motivate people and retain them, right? But if it is another fee, though, that the law has provided, in terms that you're thinking about it like, and none is coming to my head now, maybe because I'm thinking of closure now, and you say, let me go and enhance it, it might not actually be the case. But in this case, this is for something good. Let employees go on holiday, rest, and all of that, right? So yes, 6 days is too small. So if you started work and you started seeing 20 days of leave, 25, you might think that's the actual number of days. That's not the actual number, it's 6 days. And then the law says 12 days, you'd have been working for 12 months. I have seen organizations that you actually work for 12 months before you go on leave. If I have my way, I will not give anybody 12 months for you to work before you go on leave. That's such a long time. You work for 6 months, you go on leave. Kilode, why do you have to work for 12 months before you go on leave, right? But I'm saying that any organization that is doing 12 months before you go on leave, they are still on the right side of the law. It is not wrong. It is not unfair labor practice. That's the word the law provides, right? But organizations who want to just enhance their EVP, right, so that they look attractive, and then they give. So you see now, this is a good example of what I was saying, the opposite. So organizations will give less for question number 2, so that their EVP becomes strong, higher, right? So I will tell you, work for 6 months, you go and leave. I don't want you to work for 1 year, it's too long. But the first question, no, 6 months, 6 days is too small. I'll give you 20 days or 25 days or something, right? At any case, I can see your message. This is not the same with the public service rules. There is a different provision. Theirs is about 45 days or there, but I can't remember right now the number, right? But it's about 45 days, something like that. Okay, so moving on. Other things for us to know as HR professionals, right? I said earlier in this class that the time I'm giving for this there is no how, even if we do it for 1 week, there are areas that we've not even touched at all. Rights of an employee, rights of an employer, diversity and inclusion, protected classes of employees, we've not touched at all. We're not going to do justice to it, right? But just for us to close the session, wages and deductions, you can see it in section 1, 5, and 15 of the Labor Act. And this is another whole conversation, whether you can deduct or you cannot deduct. But the law, the Labor Act in section 5, actually listed the things that can be deducted, right, from an employee's wages. And even give us that if you have to deduct, there is also a caveat. You must not pass 1/3 of the person's, wages, right? 1/3 of your net pay. You cannot pass less than that. And section 1 now tells us how you to pay. It must be in legal tender and all of these things, right? Sorry if I'm now becoming fast now, but I'm dropping this here. These are the things that we have to know as well. The working hours and overtime, very important. Working hours and overtime. This is another one. Somebody is speaking, and I need to mute. Taiwo, please mute. Working hours and overtime. This is another one. If I drafted case study for all of them, we might not live here this night, right? But I love case studies, and that's the way I was trained in law and in law school. They drive you using case studies, and it's very good, because if I just come into this class and I'm just telling you this is the position of the law, this is the this and that and all, those scenarios that can play out, sometimes those things even unearth different things. Like I've been in classes where I drafted case studies, right? I'll draft a case study and I come into class and I'm seeing it from one point of view, and I deploy the case study. Guess what? People will start giving me other sides of that case study that I never saw. Even when another person has reviewed it, people will start giving me, and that's the beauty of it, because you don't know it all. Somebody will see another scenario from it and tell you, from this side, I can see X, Y, Z. So case studies are very fantastic because they are very unique on their own and have different circumstances, right? Working hours, the law did not provide for a specific number of this thing to say we are going to work for. Okay, is that what you're dropping? Hammer says 8 to 4, right? It has to be agreed. It has to be by mutual agreement between you, the employer, and the employee. If they put 8 to 5, you sign it, you've agreed. Or collective bargaining, we mentioned the unions, or industrial wages board, right? I don't know how industrial wages board apply, but I think it has to be like, how we have the unions as well. Maybe you say NUT or something like that. That's the best of my knowledge. I don't know how that applies, right? But they can fix the hours and agree to it. If somebody knows it, you can drop in the chat. But away from that, it's a mutual agreement. You don't just wake up and impose it. You would have agreed it. But most importantly, what the law also stated is that if you tell me that my working hours is 8 to 4, if I work beyond that 4 p.m., it is overtime. anything, overtime is defined as anything that's any time that's now, goes beyond that agreed time is now termed to be overtime, because the law did not explicitly tell us this is what constitutes overtime, like, or how do I put it now? Distinct definitions of it. So if we've agreed that it's 8 to 4, beyond A4 is now overtime, right? So that's overtime. But then it now gave us in section 19 how to also now calculate, pay, but it never gave us for Nigeria the actual formula to use to calculate overtime. I just have to drop this here, right? So you see different organizations using different things, and then I see different people saying the best practice. I don't know what the best practice is as at this time, right? So, but I will always say that organizations are at liberty to deploy overtime calculation however they deem fit, because right now the law did not give us how to do it. You can get in this organization, they tell you, I'll calculate it using this, maybe they'll get your salary, divide your salary by the hours that you work per month, and get 1 hour of your pay, what your pay will be for 1 hour. And then they can now say, okay, I'm going to pay you times 2 of that for overtime, or 1.5 of that. It can be different things. So right now, I do not know of any, calculation legally that the law has provided for overtime. And then the law also provided for leave, rest, holidays from section 16, 18 to 19, right, where it provided for the annual leave, the sick leave. Sick leave is section 16. Section 18 is the annual leave. Section 19 talks about how you have to calculate the leave in itself, right? Those are the things you mentioned there. Sick leave, the law recognizes 3 types of leave in the Labor Act. There is the sick leave, right? Sick leave, which is the 12 days of leave. There is section 54, providing for maternity leave, right, which is the 6 weeks. And then there is this 6 working days by section 18 of the Labor Act, right? Okay, so I'll move now. These are other areas that a HR professional must master. Data protection laws. What did the law say about it? Non-disclosure agreements and its importance. This disciplinary procedure. You see this one, very, very important, because most times employees exit through disciplinary procedure. So if you get it wrong there, your organization might be opened up to legal suits. Employers' rights and employees' rights, discrimination laws, health and safety at work, right to work, eligibility to work, Equity Act and protected characteristics, diversity and inclusion, right? These are the things for us to be aware of. Now, this is our last case study. I have just about 3 slides to go. Oh, no, that's not 3 slides. Okay, yeah, because the other one is just thank you and question. But please, I want to plead that somebody reads this for us. This is I'm very passionate about this. And this is something that, I am driving as an individual as much as I can. And my voice can be heard, alongside, some other lawyers as well. The reason I had to put it, but I put it at the end, like I'm already done. I just have like 2 slides, the common mistakes and all of that, but I'll need us to just take on this case. Because the reason I did this is if I put this case as a full-blown this thing, right, and start dissecting it and the things, we'll spend probably another hour or more, right? So I said if we have the time, we'll take the case. That's why I put it here. But I'd like someone to read for us, please. And then let's discuss and close. Please stay with me. We're almost at the finish line. Okay. Can we have a volunteer, please, to read for us? Who
Okay, let me take it.
Please go ahead, Ade.
All right. In March 2025, Joy, a senior audit associate, at Do Me, I Do You accounting firm, a mid-sized private consulting firm in Lagos, formally notified the HR manager, Mrs. Abby, of her intention to commence maternity leave. Joy was in her 3rd trimester and wanted to ensure proper planning for her workload and transition. Mrs. Abby advised her to apply for 12 weeks of maternity leave in line with what she described as company policy. Joy submitted her leave request, which was approved, and she proceeded to observe the full 12 weeks period. Joy resumed in July 2025. In October 2025, Joy sought to apply for her 12-day annual leave, citing accumulated leave days and the need to attend to personal responsibilities. Our immediate supervisor, Mr. Ikem, reviewed her request and approved it. However, Mrs. Abbey declined the leave request, stating that Joy had already utilized her maternity leave and should refer to the staff handbook for clarification. She implied that maternity leave and annual leave were not to be taken within the same calendar period, that is, same year. Confused and frustrated, Joy reached out to you, her trusted HR friend, for advice on whether her rights were being infringed upon. Advise Joy and next, and by extension, all parties. That's all.
Thank you so much, Ade. Thank you. Let's analyze this case and dissect. Who is going to, take on this case for us? Advise Joy, and by extension, we're advising the other parties here. Who is going to take this for us, please? Anyone can go. Do I have something in the charts? According to government, okay, this is speaking to something else. Lola. Uncle K, please go for it.
Okay, quickly so that we don't stay too long. Okay. According to this, the HR has already said it, that it's clearly written in the handbook that she takes 12 weeks of her maternity leave, and that is annual leave consuming. So if it is already in the handbook that maternity leave is annual leave consuming, she cannot take that other 12 days that she's requesting. It's in the handbook, and she has signed to be part of it. So that is what I see here, and she should just go and oblige and abide by the company's handbook. Thank you.
Thank you so much. That was Uncle K that spoke. Achibong, let's hear from you. Uncle K says if this is already stated in the handbook, she cannot take this second leave because it will not apply. The maternity leave has consumed this. Achibong, let's hear from you.
Okay. I guess since it's already stated, then that works. But then I am actually looking at something wrong with whoever drafted that handbook, because I would imagine that maternity leave should be something that should stay mutually exclusive from, the annual leave, right? People who have to give birth, and that should not infringe on other rights that they may have as employees in an organization. So I imagine there is something wrong, and the handbook might need to be reviewed.
Thank you so much, Achibong. Achibong says he thinks there is something wrong. The handbook might need to be reviewed. That's advising the other party that there is a difference between the maternity leave and the annual leave. Thank you so much, Achibong. Let me see. Is there any other hand that is up? Any other person? We take from one more person and we close. We are okay. There is something in the charts. Let me see. Okay. This is also saying that there is a difference between the maternity leave and the annual leave. Okay, I have more things in the charts now. There's a difference between the maternity leave and annual leave. Says, we'll drop that now. Sarah, thank you. Friday says, though written in the handbook, but the handbook was not in line with the international labor law. Friday, thank you. Beth says, what some staff, where did that go? Do is to take the annual leave in the first quarter, then go for maternity leave. Beth, please tell us answer the question for us. Beth is telling us how we can, this is, like, is this a convert? That is the word now. But we want you to answer the question, Beth. Etini says maternity and annual leave are two separate provisions in the Labor Act, the labor laws. Spot on, says Etini. Thank you. Joy says, Pascal says, Joy is entitled to maternity leave and annual leave. HR should consider and grant the annual leave unless the handbook explicitly states otherwise and the clause is legally compliant. The company should also use this case as a learning opportunity to strengthen fair and compliant workplace practices. Okay, so let me bring it together. Thank you so much, everyone that have spoken or dropped frames in the chart. So like what we've seen here, and I'm closing, right? We are just bringing this to an end. So just in case I'm dropping things that might just make you reflect. I think it was Etini and Archibong, and then maybe one other person that said that these two leaves, they are distinct. Now, this is something that I'm so passionate about, right? Like, I can take you on this, like hours on end. The law provided by Section 18, 6 working days of annual leave. It says if you've worked for 12 months, you go on annual leave, right? For 6 working days, which we've agreed on this call. There was a reason why I put that first, and then now arrived at this. We agreed here that this even needs to be reviewed, but let's not even talk about that. And the law did not state there. Very important, very important. Please, if you do not take anything away from this class, please take note of this. Section 18, and because of time, like sometimes when I'm also facilitating classes, and let me say the platform that we are using, right? The platform that we are using, I might not want to do that because I also understand some, restrictions around the platform. What I would have just done is to bring down my presentation, and I'll zero in because I have Labor Act opened, of the background of my system, because I have it everywhere. I have it on my phones. I have it here. It's just something I'm always looking at. And for us to just read that part, how it comes from the Labor Act, and that's to tell you how passionate I am about it. The law did not state there that this annual leave is for men only, or for women, or cannot be taken by women that have taken maternity leave. The law never mentioned this. It said if you have been working for 12 continuous months, you are entitled. It's an entitlement. It is not a gift. It is not a reward. It is not a benefit. It is an entitlement, all right? You're entitled to 6 days of annual leave. So this applies to both men and women. And if I'm changing my voice or my voice is going higher, pardon me, it's because of how I'm passionate about this part of the law. Now, if you leave this and now go to Section 54 of the Labor Act, Section 54 says, in fact, before you started that section, you will see there is a different section. It tells you protected classes of employees. That is to tell you that these people, like, the law is passionate about them, like, carries them like egg, right? That these people are protected classes because the law is aware that these people can be discriminated against, right? So the reason is that these are protected classes. I want to protect this class so that I don't discriminate against them. I want to fight for them, so to say. And Section 54 now says that any woman working in a private, agricultural, industrial organization or provision, or, just trying to say, where you're working and all of those things, that you'll be entitled to 6 weeks of leave before your confinement. Confinement is when you're giving birth and you're now, nursing the baby. And 6 weeks during your confinement. 6 weeks for 6 weeks, add it together, that's the 12 weeks that we practice today. And I must stop here to say that if your organization gives you 3 months, be happy. If they give you 3 months off, that's 3 months, food, 3 months. I also learned this on the job. When I was pregnant the first time, my organization gave me 3 months. I thought it was 3 months. I've never interpreted the law the way I interpreted it. Every day, just keep seeing. When I was pregnant the second time, the organization that I worked in gave me 3 months, and I thought it was 3 months, like January 1st to March 31st, 3 months. But not until I worked in an organization and I was given 12 weeks on the dot. Do you know that 12 weeks comes to 84 days, not 90 days? I learned it on the job, hard way. And I wanted to argue. I said, why is it not 90 days? How can you give me 84 days? And I had to go back to the act to look at it. It said 12 weeks, and I calculated 12 weeks. It landed me on 84 weeks. In fact, the HRS in that organization, it makes you, when you take it, you just see it that it is 84. That was when I learned firsthand that it is 84 days, not 90 days. But that's not the catch for this conversation, right? I'm saying that the law already provides for this. And he put the essence there. If you're not pregnant, you can't take this. It is for someone that is pregnant that has had a baby and is now going to nurse that baby and take care of that baby. Now, the catch now is that there is something we call impari material in law. Impari material means that there are some sections of the statute, right? That when those sections are provided, or maybe when a particular law is provided, and another statute is also provided. When the law is talking about it, it will tell you, read this one in conjunction with this one. Like, as you're reading this, you must read this together. I've read Labor Act start to finish. I've not seen anywhere it said that Section 18 and Section 54 have to be read together. Now tell me, why someone will now sit and you now draft a HR policy that says that if you take annual leave, you cannot take maternity leave? Where did you see that in the law? What are you using to practice this? Like, what is your basis? And if I said I'm going to be asking reflective questions, right? What is your basis to doing? And I must put a caveat that this does not apply to the public service rules. When I did this, when I did a video on this and dropped on YouTube, I also put this caveat, because the public service rules have their own, their leave days for maternity leave is different, right? So they have what governs them, and I've been dropping it since I've continued. And I keep saying that when you read the Labor Act, it tell you in a private, and that was the reason why I read out those things, agricultural, commercial establishment, right? It didn't tell us in the public service rules who are employees by statute. So if these two sections are not to be read together, how did we start putting them together like they are siamese twins or conjoined twins? Annual leave, like Etini said, is meant for annual leave for both men and women. Maternity leave is meant for a woman that has given birth. And in fact, the law now went further. In fact, I love that part of I think it's the last subsection that says that subsection now says that this protects both a legitimate child and an illegitimate child. You know what this means? Because I've heard people say, like some years ago, this person is pregnant, but she has not given us her marriage certificate for her to go on maternity leave. Excuse me, do you need a marriage certificate for you to go on maternity leave? The law did not say that you have to provide a marriage certificate to go on maternity leave. It was clear there when it stated for both legitimate and illegitimate child. What is the test? The test is the woman pregnant? Has she gotten, and the law also said that you've gotten a certificate from a certified medical doctor, stating when you go on confinement. That is the test. Are you pregnant? Have you gotten that certification from a certified medical doctor saying, I'm pregnant, I'll be certified, I'm positive, and I'll be going on confinement so and so time? That is the test. It is not whether you're married, you've gotten your marriage certificate. That's not what the law said, though. So if we don't have these things, why are we putting this together? Emeka, I just saw your message in the chat. No problem, your voice is okay. You're just stating a point. This one is dear to me, it's passionate to me, right? These two sections are not to be read together. And I will drop the last reflective question. Please, I would like to ask on this call. You might want to reflect on it, you might want to drop the answer in the chat. If somebody takes paternity leave today, which I know that we do not have in the Labor Act, but we are adopting what the public service is doing, please, can that person take an annual leave? And you might argue with me, you might say anything that you now want to say, that I'm now talking about men, women. Yes, because I came from the way of why will women be discriminated against in this instance? If a man takes a paternity leave, will you deny the man annual leave? Is a question that I'm asking. Will you deny that man an annual leave and tell the man that your paternity leave consumes annual leave? Have you even heard of this before? Because in my entire years of 15 years counting, I've never seen or heard that a man went on paternity leave and they now told that man that you cannot go on annual leave. Why is this so? For the woman that had carried this baby for 9 months, went through that stress, and you're now denying her annual leave. Why is this so? And I want to drop another reflective question here. This reflective question will be on other types of leave. Why is this about maternity leave? And it's for us to reflect. If you take an examination leave, will you consume your annual leave? If I may ask. If you take all those kind of leave, you say casual leave, compassionate leave, and all, do they consume? Like, do you say you've gone on maternity leave, you can no longer take exam leave? You've gone on maternity leave, you can no longer take compassionate leave. You can no longer take, other kinds of leave that we give in the organization. Or maybe you even want to bring it. Why is it section 54 that is under attack? Have you said that you've gone on maternity leave, you cannot go on sick leave? Section 16 of the Labor Act. Why did we single out this maternity leave on section 54? I'm asking reflective questions, but I'm also very passionate about this because this is an unfair labor practice and shouldn't be, what is the word now? Promoted. Okay, I'm bringing this to a close. Common mistakes to avoid. No written employment contracts after 3 months. Avoid. If you've done oral contract, please go and give them letter of employment. Poor or no documentation. If you don't do this, remember section 36 that we said, if you don't give fair hearing, right, you get to court. The court will ask you, where is your documentation? Skipping fair hearing before termination, wrong, go. Terminating without notice or payment in lieu, wrong. You would have wrong section 11. No setting clear expectations or KPIs. You might now have issues of, what am I supposed to do? You put me on PIP and all of those things. Applying disciplinary action inconsistently. They might not accuse you of, what is it called now? What's that thing called? I can't find the word now. Like you're being unfair or something. Like your double standard. Mishandling exit or offboarding process. I'm not seeking legal guidance, right? What are the best practices? Start with a solid employment contract. But I also dropped here that there is no template that is the best, right? You might find out that you have it, but you might still need to amend some things. Define and communicate clear expectations, document everything, apply disciplinary procedure fairly and gradually, carry out legally compliant terminations, know and comply with relevant laws, treat employees with dignity throughout, train managers and supervisors. Yes, because we HR managers, you may have gotten the training, but the person that will do you wrong is your line manager, right? And you did not train them, they did not know, so they acted out of ignorance. So that thing that you know, try to train them so that they know it as well. And this is food for thought. How often do we review our staff handbook? That's what we're going now. Just think about it. How often? I worked in an organization and I saw that, I entered that organization, I saw that their handbook, the last time they reviewed it was 5 years ago. I almost jumped out of my skin. I was not the HR person in that organization, but I raised it, I flagged it at management meeting. I said, 5 years ago, reviewed. There is a difference between review and revise. You can review without revising, but not to review. I don't know how you stay for long without, at least maybe 2 years, you should at least have reviewed the policies, right? If something comes up, like we saw COVID-19 come up and made us now start to put in use of laptop policy, remote working policies and all of those, you can do one policy or you can even do an amendment and then send it out to employees. But to review the thing, just don't leave it for too long, right? 5 years is a long time. So after I did that, that organization now gave me a mandate, like I should now form a committee and review all the policies. And I did that happily, wholeheartedly, because it's something that I eat and drink. So why not? So I did it, but I wasn't the HR person in that organization, but they just told me they are giving me the project, go and review all our policies to see that it is very compliant with the employment laws, right? Do you have a sanction grid? I mentioned earlier, try to see that you have a sanction grid so that there are no double standard. I also put caveats. Sometimes you might have it and something can happen. It has happened to me. I see that it was not covered. How consistent and well documented are your employment decisions? Okay, I'd like to say thank you so much to everyone that has been. If you followed me from now until this point, I would like to say thank you so much. As we close, these are just things for you to reflect on. What is your next move? How do you go back from here to practice things that are right? Review your handbook. Will you review your handbook, update your policy, implement the right structure using your policies and all of that? Please note that HR is not just about policies, it's about people and compliance, right? The laws we are covered, we've covered are your playbook in terms of things that you need to do, are things that can put you into trouble. There are some other ones like you saw, right? And there are some that it's not that they are not there, but if we start analyzing them today, some they are there and there are sanctions, but because those sanctions are not weighty, our legal this thing in Nigeria also needs to be reviewed. Maybe the fine to pay is like 100,000. The employer will say, let me do it now. Shebi is 100,000. When the law comes, I'll pay 100,000. Some of those things are killing, our practice. And even the courts, they are overwhelmed. They have so many cases on end, right? On just long cases going, continue. That's why sometimes people might just choose to settle out of courts, or they go to other multi-door courts. Let's just use arbitration and all of that to settle, right? The law is your toolkit. Use it wisely. And I will always use this caveat. The employment laws are not just for HR people. It's for business managers. It's for business owners. It's for employees to also know. Like Emeka said, let me know my rights. I would have loved to take questions, but I'm afraid I might be unable to take at this point. But what I'm going to do, I'm going to plead with Dr. Yemi. Dr. Yemi, I want to stop here at this point, right? If we have questions, maybe I can take like one or two. We can drop the questions. Please drop the questions, right? I'll also join the group, that Dr. Yemi's group. If you have the questions, you can bring it back to the WhatsApp group. Like, bring the questions back there for me. I will answer them, right? So I will come into the platform, drop the questions that I can answer them. And, you know, it can also be collated. I've also done this in the past. Like, you collate the question, I will go back, like, I'll read those questions, I'll answer you, I'll put it in PDF and come and drop it in the group, right? I can do that just because of time. But Dr. Yemi, over to you at this point. Thank you. Thank you for listening to me and staying with me. Thank you so much, everyone. It's been a pleasure staying here, and I do not take this for granted, staying with me till this time and engaging in the conversations. Dr. Yemi, can you hear me? Is he still on the call? Can I find you? Where is Dr. Yemi now?
Unfortunately, he's not on the call.
Okay, he's not on the call.
Now. Yes.
Okay, he's not on the call. Okay.
Yes, but I guess it's a convenient place for us. I'll try and reach out to him. But by and large, you've done fantastically well. I don't think we should actually accommodate any question. That has been done in the course of the presentation. Fantastic presentation. I mean, this could be broken down into like 3 classes. Well done so much. Thank you so much for this very great, insightful, enlightening, very, you know, eye-opening and very practical also session you've had with us tonight. Thank you so much, Chinwe. Please, let's see your emoji thanking her for this brilliant presentation, masterpiece, as Dr. Adeosun usually say. Thank you so much. We really appreciate you. I think this will be a convenient place for us to wind down and close the session for tonight. Thank you, everybody. Good night, everybody.
Right. Thank you, everyone. Bye. Bye for now.
Bye.
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 All right.
Thank you so much. Bye.
Thank you, ma. Very awesome.
Thank you. Thank you too.